order this zoning meeting. Today's date's August 11th, 2025. The time is 6:30 p.m. Roll call, Joe, please.
Roll call, Trustee Vaughn.
Here.
Trustee Antonitz.
Here.
Trustee McMurray.
Here.
Also present, Joe Schaefer, Director of Development and Zoning, Paul Benson, Deputy Zoning Inspector, Peter Griggs, Bercius, Johnson, and Griggs. This meeting of the Genoa Township Trustees will be recorded. The meeting audio and written minutes will be available at Genoa Township's website, genoatwp.com, or by contacting Genoa's fiscal officer. I move to call the continued hearing for ZC 2024-05 to order at 6:30 p.m. Noted that the legal notice and exhibits were read at the previous meeting and asked everyone who wished to speak to this matter to stand and be sworn in. I swear to tell the truth, the whole truth, and nothing but the truth.
I do.
The following exhibits were either amended or updated. Exhibit G, all public comments received between November 12th, 2024 and August 11th, 2025. I want to start this out. This is all kind of new to us. I'm not going to waste time with public comment. We'll hold on that. I'm not dismissing your comments. We're just not going to do it now because I just want to get through this thing with Joe and Pete. And then the three of us have to digest it. And then I think what will be appropriate is after we've gone through this in these public meetings is we can take into account any concerned residents' comments, questions, revisions, additions, consider them, and then bring them back to the board. And then we can make any other adjustments, revisions, final it with Joe, and then we'll set a date for that hearing.
I think that sounds like a good idea because it also allows us to go back through it holistically as a team and look at it. And then I think that'll bring a lot of clarity to everything too.
What, Frank?
By doing that approach.
Microphone, please.
No, this is not public session.
All right, then email us, will you please?
Pardon?
Email us with your.
By going through that approach, you've gone through everything. I doubt that you're going to make serious changes, if changes are needed, hearing it after you've already made a decision. By that point, the decision has been made. Substantially.
I disagree.
I disagree.
I disagree wholeheartedly. I think, yeah, I disagree. I'm not going to go through all this and then just pass it through, trust me.
So there's no public comment?
Not today. All right, staff report.
I don't have much to report. You got through Article 15 the last meeting. I don't think we set sort of a target for this meeting, so we'll just see how far we get. I did have a conversation with Chairman Antonitz. I asked him if you wanted to see any of the revisions from the last meeting for this meeting, and he directed me, no, let's get through the entirety of the document and sort of go through the process you just discussed before we do any of the editing work to make sure that is the work we want to do, which makes sense to me. So I don't have anything to introduce to you. I'm just here to answer questions and take notes.
Okay, well, let's jump right into 16. You want to start? Anyone?
I would just like to address a comment that I gathered at some point through this process that I got some feedback that Article 16 jumps around, that it should be organized a little better. I would like some clarification on how the person expects this to be done. So if somebody could give me some guidance, I'm open to the changes.
And what's your how? What's going to be done?
Reorganize Article 16 and organize it better. Like, it's one thing to say that, but I have no idea. I may decide to organize it and rearrange it in a certain way, and somebody disagrees with it. So I just need a little guidance on that.
Well, I think we are providing the guidance, right?
Yeah, I think she's alluding to a public comment you received, or perhaps someone received about the document being confusing or hard to follow, or maybe the sequence of the items in Article 16 not making sense. But without specifics and knowing specifically what doesn't make sense or what they think is out of order, it's hard to really, for me, to digest any of those commentaries. Like, okay, thank you, and I want to look at it, but I don't know what to look at in the totality. And the reason I kept the order is the way that the order is, you know, I tried to maintain actually the order that it's currently in, and then I just tried to repurpose sections that were getting relocated, and then if I did, once I ran out of room, I just started adding the new sections at the back of it. So, you know, we've done a lot of moving in this document, so I'm not going to say we're not moving stuff in this document, but sometimes we ought to just be, I always just recommend we be careful, because when you move stuff, all the code section numbers change, the letters, the number, all that changes, and then we have to go through the totality of the document and make sure all the references throughout the document are, you know, up to date and correct, and we're still citing correct sections. So I guess my only advice there would be, I would probably only move stuff if you really felt like it was important to move it. Usually, if you want to restructure a document, a lot of times people will make that a separate amendment, and that's all they'll do, is they won't change any text in the document. They will literally just start changing section numbers around and stuff if they want to reorganize it. So looks like you might have something to add.
Yeah, I mean, and look, general, I know we're striking the word development standards, but general standards is really almost like it doesn't fit somewhere else. So you typically, it's a very common provision, and that's typically where a lot of the odds and ends go, which I think in and of itself makes it sometimes difficult to organize. But certainly if someone has a better idea onto how to organize it, all ears, I guess, right?
Yep.
I don't, but I will say that my big picture comment is there's a significant amount of this that is considered to be deleted from its original location. I'm sorry, I'm into 17. 16 still has the same. And that's what's so challenging going through this, is for the ones that are being relocated, it would be helpful if we knew where it was going. And it's really a lot in 17, where you've struck out a lot.
Yeah. 17 I'll probably have a better handle on, because those are grouped by use types and stuff, and I can tell you, okay, a lot of them actually are just in the new 17. So they're still there, they just have the different
Just
section
a
number
little bit,
later on.
yeah.
But a couple of them did get moved to general standards because they really are applicable to all zoning districts. So that's how I view the general standards. These are regulations that are applicable to every property in the township, every zoning district by and large. That's why it's sort of the mishmash that Pete talked about, because it has to cover so many, a wide variety of topics. I mean, you could break it up into smaller chunks and have an article on swimming pools and a separate article on, but then again, you're renumbering all the articles, and so at some point, it's just, is it worth the?
Is the juice worth the squeeze?
Yeah, exactly.
Okay. Another comment I have is section 1603.01B. I talked about possibly moving this to Article 1, or we're going to reword it.
Yeah, this is existing language in the code. I want to say this predates probably me, so I didn't see a particular reason it had to be deleted, so I just kept it. Frankly, I'm also not sure if it actually needs to be in there. I'm not sure it's imperative that it's in there. I think it's trying to just inform residents that they are responsible for that task, and it's not the township's job to come out and mark your lot lines. I did mention to Trustee Vaughn, maybe we ought to think about finding a home for it in Article 1, because it seems like it shouldn't be just relevant to fences. I would expect that for any zoning permit application. That's a house, a shed, anything like that. We would have that expectation.
I'm leaving that open for discussion. You have
Yeah,
thoughts?
I'm okay with anything that's going to clarify this.
Yeah. I mean, that's one thing I'll say, like, I think sometimes the legalese gets a little heavy.
Yeah.
So I think that that's probably some of the challenges with just the breadth and depth of the entire
And
document.
in that provision is, you know, sometimes I see it, sometimes I don't. I think it's inherent that when you file an application, you're constructing on your own property.
Property, yeah.
But as Joe knows, and as I've seen pretty much on a monthly basis, sometimes that doesn't happen. And then the first call is to the zoning department saying, you approve my permit. Right? So I'm indifferent. If you
Does
don't.
this protect us if, in cases like
No,
that?
I just think it's more informational for
An
residents.
FYI,
Yeah,
clarity.
yeah, but it's not,
Common sense, isn't
yeah,
it?
well,
Shouldn't
Yeah.
build on your neighbor's property.
I'd be fine striking if you want to strike. I don't think there's, and I don't think it needs to be in there. I don't think it hurts being in there.
Yeah,
don't-
I
but-
know.
I mean, I could see moving it to section 1, just under the kind of the general
Mhm.
things to consider, kind of steps. And maybe just remove it from here.
yeah, that's,
Yeah,
So simplify it.
Yes.
Yeah, I probably could reword that in a much simpler way.
Yeah.
than It's probably 2 sentences or 1 sentence too long.
typically where you see it is fence or some type of shed or accessory structure is typically where it comes up.
Yeah, those are the most common ones where we would have that issue, especially with fences, because, you know, you can build them right up to the lot line, and most fencing companies aren't having the property surveyed when they go out and build that fence, so it has happened before. I mean, as Pete said, it's not an uncommon occurrence, especially with older stuff, to find that fences were over a lot line somehow.
So it sounds like you like it, maybe look at a different location, but put it in layman's terms.
Yeah.
Yep.
Well, and it's doesn't just pertain to fences and walls, right?
Right.
Yeah, we'll move it to Article 1 that basically just applies to everything. I'll find a home for it and
Okay.
simplify the language.
So all this information, 1603, is just relocated.
Yep, 1603, fences used to live in Article 20, which was like the landscaping standards, which
Yep.
always struck me as very odd. I don't think a lot of people think to go to the landscaping standards to look for the regulations for the fence on their property, so.
Okay. On page 16.3, I just had a question on why you deleted the first provision under 1605 about private access drives. Individual lots that terminate is struck out on here.
The notes say it's difficult to enforce.
Yeah, because I can't really go out, I mean, I'm not gonna be able to get a depth. They can give me the drawing, but we're not going out there and doing core samples on the materials and the depth that they're constructing in the aggregate. I know fire also gets involved with a lot of that, because it's largely a provision in there to address their concerns.
And that's same thing with 160503.
Yeah, 503 is even more so, where I want no part of writing a certification that a culvert or a bridge is safe, because that's not my training. They could give me a document that says, oh yeah, this is stamped by an engineer, and if I guess it was stamped by an engineer, I'd sign off on it, but I have no, expertise, and those are engineering matters, I guess is the short way to answer it, in my opinion.
I'd like to go back to page 16-2. Retaining walls, 1603.11C. I think. Yeah, we talked about enforcement.
Yeah, that's the erosion.
Yeah,
That's one, again, that's also an engineering concern, if we wanted to get rid of that, because I agree. That's also language that's, I brought the 2013 code with me so I could reference what's been in there a while and what hasn't, and that's language is in there from before my time, so. But yeah, I would have no way of probably adequately judging that. We've already gotten rid of the other drainage language, so it would make sense to probably strike that as well.
thoughts?
Yeah, I agree.
Get rid of it?
I think it might be helpful, at least for me, is I'm not overly concerned at this point on where stuff is located. I'm more concerned about what's getting deleted and what's getting added. Do I have an agreement on that?
So maybe step
We can
through.
worry about the structure. What I think I would do is like for you to go through everything on here, like the highlighted green does not exist within the document. And I think that's really what we should be focusing on.
Yeah, well,
Additional language and what's being removed and why is it getting removed.
yes.
We'll worry about where it's located.
I'm gonna grab the computer from Paul Benson.
Okay.
I think that would be easier for you to go
Yeah,
through.
yeah.
I don't have the print of the color-coded version, I just.
Unless there's something you obviously don't like that's
Well,
been
yeah,
in
I
there
mean,
a while.
I'm in favor of just addressing everything, at least taking notes, and then we can come back to it while we're going through it. I mean, I really don't have that many comments. I have a
All this
colored,
green stuff is new.
I know, I've got it. I went through and did it by hand, because I wasn't
I had the
losing all my
compu-
notes.
The computer,
Hours.
the computer sitting with me.
I have
and,
it. I have it already. That's how I could tell you what the notes say. I wrote it down.
Yeah, I wrote them down in my first version. And I got this one.
No, I keep the same version. But at this point, I'm running out of room to write notes on certain pages.
Sticky notes.
That's what I'm going to. It's crazy.
So do you want me to just go through the green and red items then? Is that what I'm hearing?
Well, 1602 is pretty straightforward, so
Yeah.
I don't have any
Okay.
really straightforward.
Next red I see is, that was 1605, we just talked about
Yeah.
that.
So these are the ones that we get grief on. So when you talk about installation of the entry feature, how do we come about the fact that this is 6 or less feet in length? Because I get a lot of comments that these kind of dimensions seem arbitrary.
Yeah, I mean, to some degree, you just, if you want to regulate it, sometimes you do just have to pick a number of what seems sensible. So let me read this standard here. Zoning permits shall be required for instance of I think it's just, if you want to implement that concept, you have to have numbers, and in a situation like that, it's
I
more of
agree.
a just a look and feel kind of thing, of what do you think looks and feels appropriate. I wish I could say zoning was always scientific and technical, and there's always, but sometimes it is just look and feel.
Okay, if you're okay with that, let's go to 160802, following architectural features not otherwise exempt. And that's just a setback, rear
Yeah, and
yard,
actually,
maximum of 10
that
feet.
initial section, the 16802, could probably be considered relocated text, because if you look further down, there's a red line that says, that's crossed out, that says, may extend into the required front and rear yard a maximum of 10 feet. So that
Oh,
coloring
right.
probably should have been like purple,
Yeah,
where it's just relocated text, I just worded it differently. So that 10 feet standard already exists. And then the rest of that new language is really just elaborating on the concept and providing greater clarification for administrative purposes.
Do we like the 10 feet? We okay with that?
I mean, it's been like that for years.
It's it works.
Yeah. Any comments about accessory building 160901?
Only, is this the spot where we talk about the chart, and is this the part where we talk about whether it has a foundation or footers? Anything delivered on a truck?
This is the section where the gentleman requested that you consider increasing that 120 to 200 to match the building code, which I'm not opposed to. For what it's worth.
And there was, at some point, it was a suggestion that the square footage be considered on the size of the lot.
Yep.
Like if a person has a 10-acre lot, it just doesn't seem reasonable to hold them to 200 square foot. I didn't want to create another chart, but it didn't seem to make sense that,
Well, the 200 square foot is just the threshold for when you don't need to even ask for a permit. We won't ask you for a permit, we're not even gonna count it towards your accessory building count. Anything above 200 square feet, you'd have to pull a permit, and it would count towards the maximum number of accessory buildings you're allowed on the property.
Is that typical? Typical zoning? Other townships do it?
Yeah, I mean, most townships will limit the number of accessory structures, but you also could in terms of, I guess, maximum square footage. It is probably more typical in rural areas to see that chart like you were explaining to allow more room. You probably have to, I mean, I'm not opposed to the idea of a chart, but your numbers are probably going to be a little bit different than you would be in a rural community. But yeah, you can do a chart, absolutely. That's not uncommon.
consider that?
So the current ratio, just in terms of the, are we talking about a chart for the size or a chart for the?
Size and the number. I think the more property you have, the more accessory buildings you should be allowed.
So we do have the ratio of, you're currently allowed one accessory building for any lot, plus you get one for each full acre of property you have, but the max is currently 5. So,
But if you own 40 acres, you're only allowed 5 accessory, I don't
Yeah.
think that's fair.
I mean, we could either do a chart or, well, I guess we could look at doing a chart. Yeah, if we want to say over a certain number of acreage, I don't know what, I mean, I think someone provided a chart somewhere. Yeah, if we want to allow more, if you want to allow more, I know there's people out there who would be happy to do it.
Or, yeah, or you could simply, I have some codes that it's just the maximum square footage, right? I mean, you can do it that way too.
Like
Total square footage of accessory structures. You can look
Cannot
at it that way.
exceed.
You can do both. It's completely up to you guys in terms of how you want to look at it. But I think in a more typical subdivision, it's probably where you want to limit, I mean, my perspective, limit the number, right? Because you don't want.
Yeah.
You're talking PRDs would be separate, yeah.
Yeah.
Which usually their HOA is going to restrict whatever they do anyway.
Yeah, if they even allow.
Right.
I mean, I feel like by and large, for most properties, the current standard works. It's the larger properties, the more affluent properties are probably where we're seeing this issue mostly. Where,
Yeah.
The people who are bringing this in already have 7, they want an 8th.
Yeah. I see it a lot with car collectors. It's been popping up in some of our clients where, they got a lot of property and no one can see the structure and, but they're at their, they're at their limit. But
Sometimes what we'll tell people is just expand your existing building. Like, we have, in like the straight districts, lot coverage restrictions. So if they can stay under their maximum building coverage percentages and their maximum pervious surface percentages, and they want to just expand that accessory building, because we don't cap the size of the accessory building, that's sometimes a solution for them too.
do you guys want to see like a couple samples of what some other?
Yeah.
Yeah.
Okay.
That'd be good. But going back to the accessory buildings exceeding 120, if we were to change that to 200, so if it was 200 or less, they would not need to pull a permit.
Wouldn't require a permit, and it wouldn't count towards that 5 I was talking about. So theoretically, you could have 5 plus however many sub 200 accessory buildings you needed or desired.
I don't know that we want to have a garage sale of,
Well, I think that's what that's
sheds
trying
from
to
Home Depot. Yeah, I don't
I think that's
think,
been sort of the concern is, and that's why I think that the number is the 200 square feet, because I mean, that's, yeah. I guess someone could buy a bunch of Home Depot sheds and just pepper their property out of.
yeah, I don't
spite,
want to see
but-
that. So whatever we have to do to prevent that as well.
Well, then you would have to eliminate that provision. or say that you're allowed X amount of exempted buildings.
Yes.
Yeah, that would make sense.
Have you seen anyone do that before? You can. It'd be interesting to administrate, but
It's okay to be different.
yeah, it's okay to be different. Thank you.
All right, so what are we gonna do with that?
Well, I think Pete's going to get us a couple samples of a chart.
It depends on what district you're in,
Yeah.
residential, rural residential versus suburban residential versus PRD.
Well, PRD, we're going to keep tight, but the other two, I think we can allow to expand.
Let us kind of formulate a strategy based upon where I think you want to go, and
Yeah.
we'll get you some samples, and then we can flush it out, I think.
Probably do it based on acreage as
That's what
opposed to
that's
zoning
what I would
district.
probably
I
do.
probably wouldn't go by zoning district.
Yeah. I think acreage makes
Because if
sense.
it's a 5-acre property in SR as opposed to a 5-acre property in RR, I'm not sure why that would make a
Yeah.
difference.
Yeah,
So acreage can bring that
Because
protection.
it sounds like we're talking about mostly the larger properties. Most of the
Yeah.
larger properties are gonna be RR anyway.
Yeah,
There are some larger SR properties, but not a bunch of them.
all right. Pretty
And then
much.
are we gonna change accessory buildings exceeding 200 square feet?
I'm okay with that.
Yeah, I'm
Okay.
okay with increasing the number.
And then, but did you want a cap on that exemption?
Yeah, I do. I don't know
Yeah,
what
so
that
some
number is.
exemption, like,
Fine?
No, I don't know. I mean, I would think any more than 2, you're starting to have a garage sale,
Seems, I mean,
right?
we're already being generous by giving you
200.
2 free buildings that you otherwise didn't get
Mhm.
before, so.
I think 2 is plenty. You okay with that?
so if they wanted to add a third 200, they would have to
You have to
apply.
pull a permit for that.
Yeah.
I mean, Paul, I can only think of like 2 properties we've run into that issue with recently. You think of any? You probably know the 2 I'm thinking of.
The main issue that we have with those is usually on the smaller lots, people that have 0.7 of an acre in SR that already have a shed for their lawnmower and their wheelbarrow, and then they go buy a little pergola at Costco and they want to put that on their patio, and they can't because they already have the one accessory building.
Yeah, actually, that's probably the bigger
That,
problem.
that's the one that we've run into the
More
most.
frequently.
So
is-
in this case, you could have both, because we said 2.
As long as one of them's underneath the
200.
threshold, and normally, like, either the small shed that you keep your lawnmower in is gonna be under that, or the pergola from Costco is gonna be under that.
Yeah.
I would agree that that's more of a common
Could help.
problem than the large
So
property
this
that
would help
wants-
resolve that.
I would
Yes.
say so.
Okay, that's good feedback.
But I
Joe-
also share the concern about you don't want 50
Yeah,
of
I
them
don't,
out
yeah, I
there.
don't want a bunch of them. Joe, we talked today about the, on B, the 10 feet. Can you address that? Because it used to be 15, why is it now 10?
Changed that several years ago just to make it consistent across the board with swimming pools and just, it was hard to answer the question of why are swimming pools 15 and accessory buildings are 10? And like, the numbers were just all over the place and it just seemed, I don't know, the impact of a pool versus an accessory building to me is relatively similar. You either have a vertical surface 10 feet away from you or you have a pool possibly full of screaming kids 10 feet away from you. So I think it was just trying to streamline numbers, to be honest.
Mm-hmm. And then D, with the, changing it from 3 acres to 2 acres?
Yeah, that was just, I don't know where the 3 predates me. That's, might be my phrase of the night. I have no idea where it came from. Doesn't make a lot of sense to me. We don't regulate anything on the basis of 3 acres. 2 acres is the obvious, as you know, the minimum lot size for RR. So it just seemed, again, it's sort of like streamlining numbers of why wouldn't we just make it consistent? And I think it'll help some of those people on those, because properties of 2 to 3 acres, or between 2 and 3 acres are, I mean, we see, that's not uncommon. So I think it would help those people out.
On
2 acres is pretty big.
1609.01D.
That's the one that pertains to building heights, accessory building heights. For some reason, we were saying if you were under 3 acres, you couldn't go taller than 22 feet. I'm just proposing to change that 3 to 2 acres, because I feel like a 35-foot accessory building on a 2-acre property, it doesn't seem
It's
egregious
blue.
to me.
And then also 1609.02, are we increasing this square footage as well for accessory structure to 200?
Oh, we can.
Should 1609.01 and 02 be, they look similar, but should they be similar?
Yeah, that's what I was just thinking. So 16902 talks about accessory structures. So this basically covers anything that you would require a permit, but doesn't necessarily qualify as a building. I think I put that in to just try to be consistent. So think of it, an accessory structure would be something like a deck, probably the most common accessory structure that we would see.
So leave it at 120?
I'm starting to wonder whether or not we actually want that concept in there. Because most decks are going to be under 120 square feet. Well, not most, some. Not most, I guess not most, but.
10 by 12, not very big deck.
No, but smaller ones would fall under that threshold. So would you be okay, oh, well, it has to be in, it has to be less than 6 feet in height. No deck's going to be less than 6 feet in height. So it's just trying to cut a break to the small stuff.
I say leave it, I guess.
To leave it at 120?
Yeah. And then on that section A, why don't you list all of the accessory structures? Why don't we do that?
Yeah, usually, there are times where I try not to list everything because I don't want to create what's might be perceived as an exhaustive list. And then accidentally, we forget something or something comes up we just didn't think of, and have it not be on the list. So every building is a structure, but not all structures are buildings. So, and there can be a lot of different types of structures, and I just thought it was not possible really to think about every single iteration.
In our definitions, do we define structures?
Yep.
Okay.
Find building, a building is a subtype of a structure.
And can you talk about the loophole? If we
Oh,
don't
yeah.
define them the
So,
way they are?
we define building as anything that has a roof over it. Even if there's no, even if it's not fully enclosed. If it's got a roof over it, we're counting it as
So
a
a
building.
pergola.
If it has a solid roof, yeah. I think we've tried to clean that up a little bit. 'Cause
Okay.
the pergolas didn't make a lot of sense.
Okay.
But basically what you can have happen is, and this is very common, we'll see people, they'll put on a deck. And then they I want to put a roof over part of it, get some shade, okay. Well, and we can do that, but then they could always come back, and what eventually happens with those roof decks is, I want to turn it into a 3-season room. Now they've enclosed it, and they don't have to pull the permit to do the enclosing from zoning. They just pull a building permit from then they've magically now taken their house and expanded the footprint of their principal building. That deck was complying with the accessory structure and the 10-foot encroachment provisions for architectural projections. But once you roof it and then you've enclosed it, now it has to technically comply with the principal building setbacks, and you could have now created a non-conforming situation when they enclose that deck. So we don't want to have that situation happen, so the theory has always been over the years of if it's got a roof, we're calling it a building, part of the building. If it's attached to the house, and if it's a roof deck and the roof's attached to the house, we consider that part of your principal house, because you could always enclose it. Same with, though, if you were to build like a standalone deck out in the middle of the yard and put your roof over it, like a gazebo or something, theoretically, you could enclose that, and it could become a full-fledged building, and now, it's out of count towards your building, numbers and all of that, so. that is a loophole that we try to close out. We've tried to wordsmith this, I think, a little bit to try to be a little bit more forgiving on the roof situation, so we're not getting too carried away with like the pergola situation. We don't want to penalize anyone for something like that.
Okay.
Joe, we talked about nuisances today.
Mm-hmm. Yeah, so, in the nuisance section, sorry.
You had some language. It's
Yeah.
1611
Yep,
nuisances.
1611, yep, there we go. So, one of the oversights in this was we're missing a code citation for the ORC. We had 50587, but we don't have 505.871. So we're adding that. Talking to the prosecutor's office and trying to administer this code section lately, they did recommend possibly, because it's a little bit of a gray area in terms of how it's currently worded as to whether or not we could go after any of those items that's listed as a zoning violation. We say we could treat them as a nuisance, and we say we could also possibly enforce it via the provisions of 116, but the prosecutor's office thought maybe we ought to add language, something to the akin of other legal remedies, including the filing of a civil complaint, just to leave the door open that if, for whatever reason, we didn't want to pursue it as a nuisance, the option is still there to go after it as a zoning violation. Pete, does that make sense? You?
Yeah, I mean, it makes sense. I mean, 505, 86, 87, and 87.1 are completely independent of zoning. I mean, now, I think what you will see is more of what we call a public nuisance. And giving authority under zoning, so something that you would not be able to necessarily capture under 505, 86, 87, and 87.1. That is your typical zoning resolution nuisance provision, right? That's what you want in your zoning, because it gives you another mechanism. But in terms of, I'll be honest with you, I'm indifferent. I don't think it's necessary to have really any reference to 86, 87, and 87.1 in your code. But, once again, it's completely up to you guys.
So I can tell you which of these standards particularly triggered that conversation. It was the junk vehicle standards. So we have in here where it talks about junk vehicles, and we have in our that you can't keep them for more than 7 days on the property. And then we have a definition of junk vehicles. I learned, I think last week, that our definition of junk vehicle doesn't match
It's correct.
the state's definition of what qualifies as junk vehicle. So
Correct.
we were looking at a situation where we were going to try to go after maybe possibly having the board declare this vehicle a junk vehicle, and I ran it by the prosecutor's office, and they said that vehicle doesn't meet the revised code standards for a junk vehicle because it has to hit all the items in this list, and it doesn't hit all the items in this list. In our code, it says you only have to hit like 2 of the 4. So I think that's why they said, well, maybe you ought to tighten up this language to basically say you could still go after these items as a zoning violation. So that way, even though it doesn't meet the ORC standard for a junk vehicle, if you think it's a junk vehicle under your zoning standards, you could then file a civil complaint against it and address it that way. So I was trying to provide that flexibility to people.
Yeah, no, certainly you can have a definition of junk motor vehicle that is not in 871 in your code. You would pursue it as a zoning violation, and you can definitely do that.
So the prosecutor's office just thought we needed to tighten up that language a little bit just to make sure that that code section tells us we can go after it as a zoning violation. Because right now, it could be possibly construed that we can only go after it as a nuisance under
Right.
505. So, yeah. I thought the existing language that referenced to section 116 did that because that's the section on enforcement. But the prosecutor's office seemed to think that that needed to be strengthened a little bit. So I can look at taking the verbiage he gave me and trying to fit it in if you want me to do
I think we need to do whatever we need to do so that whatever's in here isn't enforceable, because right now it isn't, we found. So whatever we have to do.
I would say we would do that. Generally, I'm gonna prefer to go the nuisance route on most of those situations. Because I think it's a quicker, more efficient, long-term solution. But I don't wanna close the door on the civil complaint zoning violation route. If for whatever reason the nuisance abatement route isn't gonna work, we at least have a plan B to pursue. I think Rafiq's familiar with the IPMC, the International Property Maintenance Code, from his prior employer, and he suspects what we define as junk vehicles in the zoning code is probably pulled from the IPMC as opposed to the revised code.
I'm pretty sure it is, yep.
So then does 161102B, that references the 7 days shall not be considered a violation, that's okay?
Yeah, we're saying you can have it on your property up to 7 days, and then you gotta get it out.
Yeah, yeah, okay.
And I mean, I know you've got verbiage from the prosecutor's office, but I do like, if I understand Pete correctly, we can create our own definition of junk vehicle, and if it doesn't match the ORC, it's still enforceable because it's in our code?
Yes.
Yeah, I like
What we
that.
would be doing with the prosecutors like this.
Okay.
So we already have junk vehicle.
Okay.
That's already a defined term.
Because that way, if the ORC changes, and like you said, they have lower standards than we do,
Mhm.
right? So, yeah.
871 is the newest of the statutory nuisances. So back in the old days, you had to rely upon zoning resolutions to remove junk motor vehicles.
Which is also probably why it was in here to begin with.
Yeah, yeah. Okay.
But 871 still says it has to be, one of the standards is inoperable. Apparently inoperable, which can be difficult. The prosecutor's office did think that was gonna be a tough standard to prove. Our standards, just for reference, since we're talking about it.
So apparently inoperable under the case law is viewed in the eyes of enforcement. The toughest standard is actually the third criteria, so it's 3 model years or older,
Yep.
right? Apparently inoperable. And the third element is extensively damaged, right? You got to show that it doesn't work. And that typically, that is an objective standard the court has held. Apparently inoperable is subjective, the courts have held. So trying to, when you see a car that's been kind of sunk into the ground and hasn't moved in 3 years, I mean, how do you prove that it actually doesn't work,
Yeah.
right? And a lot of times, people don't get that evidence into the record, and a court will throw it out. But I'm definitely in favor of having as many tools available. So if it doesn't meet 871, and we can look at our code and say, yep, then we attack it that way. Because ultimately, what we want is to force somebody into voluntary compliance.
Right, yeah, yeah.
Exactly.
Yeah.
So we have a 5-point test, but if they hit 2 of them, we can go after it.
Okay.
Ours are vehicles without valid current registration and/or license plate. That's 1. 2 is the vehicle is apparently inoperable. 3, the vehicle is without fully inflated tires and/or has any type of support under it. 4 is the vehicle has missing or shattered window or windshield. 5 is the vehicle has extensively damaged missing door, motor, transmission, and/or other similar major mechanical or body parts such as a fender.
Okay,
So ours is, I think, stronger
yeah.
and a little easier to probably work with. Now, the caveat to that is you're going to have to do a civil complaint, and then it's going to take time, which, as Pete said, the preference is just to get them into compliance as opposed to having to go that route.
And everything's a collector's vehicle.
Right.
It's a statute in my yard.
We had one where someone, literally, we sent the letter, and then they put a tent over it, so you couldn't see it. Eventually, it
Creative.
went away, but that was their solution. Well, you can't judge it if you can't see it, I guess, so.
Can you address 1612.06?
Wait a minute.
Yeah, you got something
Wait a
before that?
minute. That whole thing has got me, that whole objectionable practices or conditions.
Okay.
Mm-hmm.
So you struck out the first paragraph, the occupation or use of any lot, building, or structure. There shall be no direct or sky-reflected glare from high-temperature processes. Okay, I get that.
Mm-hmm.
So then you're adding, you've relocated the ultralight vehicles. You're adding the operation of any drone shall comply, that's pretty standard. The operation of any remote controlled vehicle, robots on private property within Genoa Township shall comply with, okay. Okay, these are just referring to, they must comply with whatever state standard or any standard outside of zoning, right?
Yeah.
It's not limiting their use, it's just saying if you're doing this, you have to comply with.
Yeah, we acknowledge there's other agencies that get involved with how all those things need to be operated, and we're deferring to those agencies. With the exception of 161206, which was sort of an add-on of just, I think one day I got thinking, wow, what would really stop someone from doing that?
Burying their pets.
We talked about
Right.
This
this.
is human remains.
I know, I know.
So,
Okay.
so why is this in here?
I don't want someone to create a cemetery that then we eventually have to inherit and operate and
Because
maintain.
if it's neglected.
Look at, you
who's-
saw Pete's eyes, you see his
who's
Pete's
the
eyes? His
default?
eyes
Us.
widen?
Then we have to take care of it. We're protecting ourselves.
Not that that's necessary, maybe.
Well, cemeteries are a money pit for townships. They're not, there's very little funds to care for them, and we just get dumped on when they get neglected. So I think it's good to keep that in
No, I'm
here.
not, yeah, I'm just.
That way, if someone does it, we can say, well, we didn't say you could do it. If you did that, you weren't supposed to.
I don't know if it'll help, but
I don't
sure
know. If
can't
someone's
hurt.
considering doing that, I'm not
Sure
sure.
can't hurt.
The other conversations that need to be had.
You ever had anyone put anything like that in?
Besides zoning?
That, the burial?
Yeah.
Okay, because I came up with that one, so I wasn't sure if that was just me overthinking things or.
Where they request to create like a family burial site.
The animals one, yeah.
Bury
Yeah.
carcass and animals and everything else on their property next to the township park.
I wasn't ready to go after the animals because I know people are very, dogs and whatnot. It's-
Actually had one where people were going out hunting deer and then hanging the carcass in their front yard. And
Oh, no.
moms having to explain to their kids, why did the next door neighbor kill a dog? And and this isn't a traditional, what I would call traditional subdivision, so.
That is crazy.
Oh,
I believe it.
Uh-huh.
Yeah, I bet you could. 1614 C. This is a Pete question. The first word is loudspeakers. Do we need to be more specific with loudspeakers?
Wait a minute, 1614.
14, I'm sorry, .02C.
Oh,
Okay, there.
I was like,
Okay.
swimming pools.
Yeah,
Okay.
loudspeakers.
What's your question again?
Well, is that a measurable, enforceable term? Do we need to be more specific there, or is it okay just to leave loudspeakers?
I think is that more of a technical,
Yeah, so that's more, that is basically
a type?
public nuisance.
Okay,
What you have in.
okay.
Most of the equals not regulated, should apply with conditions.
Yeah, so the 161401 is like your swimming pools for your house, essentially. And then 161402 is clubhouse swimming pools, hotel swimming pools, swim club, that kind of stuff.
Yeah, unless you want to, once again, it goes back to that conversation that we had last time, unless you're gonna start crafting decibel levels. The one thing we could look at is maybe cross-referencing this section with, I know that was one of the workshop
Yeah.
verbiages that we were gonna,
In some of those other districts.
maybe we could cross-reference it back to that standard that we developed.
Or do we need, if we have the standards in the districts, do we need to add it here?
Because really, what you're end up doing is going in front of a judge and arguing a public nuisance. And, you know, nuisances are kind of like the definition of, the legal definition of pornography, right? You know it when you see it, right? You know, what does that mean? It's, what's annoying to you, maybe not be annoying to me.
So if this standard wasn't in there, you're saying the township could still go after a concern as a nuisance as opposed to a zoning violation? Is that what I'm hearing correctly, or?
Well, I want to go back and look at the previous noise
Okay.
provision that we had.
Yeah.
And I think that may capture
This,
this,
This-
but you could, at a minimum, cross-reference this section back to the one that we're going to take a look at.
okay. I'm just gonna make a note, work with Pete on that one.
And then we're establishing that, kind of that reasonable person standard, which I think was the goal of the earlier conversation.
Yeah, I definitely want the document to be consistent and something we can actually administer, so.
So this says only if it's installed within the building, so that means you can't put a portable speaker out on your pool deck and play music?
Not if it's public.
Yeah, this is public.
Yeah,
This
these are
is
just
not-
like the hotel pools, clubhouse pools.
This section only, 1614.02 is for public pools.
All other.
Yeah, any other pool that isn't
Oh.
considered a private accessory swimming pool for single-family dwellings and other similar types of residential type
So
uses.
like an
got
apartment
you, I
building
got you.
pool or
I got you.
golf club pool.
Yeah.
Even an HOA pool, right?
Yep.
Yeah.
Mhm.
Okay.
And then we talked about hours of operation here. Do we put those in? Do we leave them out?
I'm sorry, what was that?
There is not.
Yeah, there aren't any hours of operation here. Are we good
Pools?
with that? Yeah.
No, I wasn't sure. Put them in there. Historically, I've not been a huge fan of hours of operations provisions. They're not the easiest, from an administrative standpoint, the easiest things going for us. And I feel like you have disturbing the peace laws and other, my guess is that the pool's causing a problem at 2 a.m, there's other things going on other than just the fact that the pool's open. They're probably doing something else they shouldn't be doing. The cops will probably show up, and even if they can't cite them, we'll tell them to, hey, keep it down. And my guess is a lot of times if a cop shows up, that tends to, I would think most people comply with that. If they don't, my guess is the cops are gonna show up and they're gonna do something else that's gonna give the cops a reason to possibly intervene further.
Yeah, we could probably grab them under the noise section that we're working on.
Yeah.
I think that would be your enforcement mechanism.
Okay.
But I generally still prefer police deal with the noise, because usually it happens very late at night when I am not here.
All right. I don't have anything else in 16.
I don't either.
Okay. Nothing on home occupations, it must primarily relocated.
Yep, that was one of those former Article 17 standards, and because they could apply to any district that has a house in it,
Yeah.
we wanted it in 16.
1620 cluster box is a whole new section, right?
Yes, that is
And
brand
that's
new.
Pertaining to postal deliveries, right?
Well, yeah, this is, the post office, despite the growth of these areas, still wants to treat a lot of these mail routes like it's decades ago, and they still consider them rural mail routes. And so they refuse to now drive into the neighborhoods to the boxes in front of the homes, and now they're making all these, despite the fact that they're already doing it all over the place in Genoa Township, they don't want to apparently do it anymore. So any of the new developments have to do the cluster boxes, which, I don't know, but trying to reason with the post office is good luck. It's impossible. Developers have been fighting that fight for years. They're not getting anywhere. I remember 10 years ago in Pennsylvania, I was dealing with this, the same thing, and it was like, I don't mean to speak ill of my other public servants, but trying to talk to the post office about this kind of stuff is difficult.
I mean, can't you just say that these have to be compliant with the local postal service?
They don't have standards. I mean,
Oh,
their
yeah.
standard would be an ugly vanilla box, metal box.
Okay.
That's all they care about. If you want something nicer than that, we're gonna have to regulate it. Now, if you think this goes too far, I mean, we can pull back. It's fine. I know we had, the zoning commission got one public comment from an individual who was against the standards in this section.
What was the reasoning?
I think they were interested in creating a subdivision. And thus, we're gonna have to follow these standards.
Oh, got it.
But maybe they work for the post office.
No, I'm sure I just didn't make any friends, but the postal carriers, they're great. The people who deliver my mail, they're great. But the higher you go up that ladder in the bureaucracy, it gets difficult.
So we really need a roof, a decorative bench, and a decorative waste receptacle? I mean, is that, I don't know that I've ever seen that in
Yeah.
all these.
Yeah, I mean, that's been our standard, right? That
Well,
you,
we don't have a standard, right?
This is all new.
I've been asking people
yeah,
to
you've
do
been
it.
asking for it.
Some of them do
Yeah.
it and some of them balk at it.
Okay, yeah, I like the standard.
Have you-
I
have
think
you
they
seen
should-
people
They should
put a
have a
standard?
handicap space. I mean, if you go get your mail and it's pouring down rain, it should be covered.
Yeah, so I think until you get the I, really, that's, you know, completely up to you, right? I don't have an issue with those in there, you know. Some will have them. I would probably say more don't, but that doesn't, you know, I don't have an issue with it. It's really a policy decision. But most of what Joe has in here is pretty standard. The decorative waste receptacle, decorative bench, those type of amenities is
We
probably
did not mention
uncommon.
ADA access.
You don't need it?
I would think you'd have to.
I think you would too.
Someone gets out of their handicapped vehicle.
Yeah, I agree.
I agree.
And I don't know if ADA already would address that or not.
Is that in there?
No, it isn't.
Yeah.
Why don't you think about some language, if you can even refer to whatever the,
Regarding accessibility.
yeah, the national code for ADA access. Because then that will cover everything, including grades.
Yeah, we can put that they just have to be ADA compliant.
Yeah.
Yeah,
That's usually a good cover. But I think Pete was saying that you were sort of mentioning I as
Yeah,
a
no,
little.
the eye, I mean, I think, you know, in terms of the roof and maybe the light, you know, I mean, to me, the waste receptacle kind of makes sense, you know, people, but I don't know, like, I don't know how many people open their mail and sit down next to the mailbox.
I
but-
don't think you need a garbage can if they want to, because then I look at who's going to empty it, right?
Well, and that was the
HOA.
concern raised by the public comment,
Oh, right.
Yeah.
yeah.
Yeah,
that they would have to maintain all these amenities, so.
Yeah.
Um,
but, I mean, as far as the bench and the light, the roof,
I think the light in the roof makes sense, the bench.
yeah, I don't know that you need, we don't need to require the bench or the trash can,
I'd
but
say
we
it's-
can
it's simply
suggest.
taking shall out and say may.
Yeah, that's what I was just gonna recommend. Maybe it's one of those, we want to push people that direction,
Yeah.
but maybe we're not going to make it a requirement quite yet.
It's just one more thing, you gotta enforce those
I mean-
four things.
I mean,
And
the-
it's a cost that they have to incur.
Yeah.
And something they have to maintain, that the HOA is going to have to maintain, so.
Well, what about the roof and the pedestrian?
I
scale
still don't
light?
think it's something you can require, should require.
Yeah, I agree.
So make it a May.
You can make it a May for now, you can always change it to
Yeah.
shall in the future. At least it's, the concept is in there.
Anything on electrical vehicle chargers that concerns anyone? Not either. Are we ready for 17?
Yeah.
Ready for 17?
I have no problem with this 1701. I like, in fact, I like the addition of the preserve, extend the charm, provide well thought out. I like all that language.
I just had a question on 1701E. Context sensitive and environmentally conscious. Just, should we define those?
Context sensitive is a defined term.
It is.
Environmentally conscious, we don't.
Okay.
Again, because this is the intent and purpose section, I'm not sure you need to be as definitive as to exactly what those terms are.
Yeah, it actually helps us.
To be a little
Yeah,
bit more
sometimes,
gray.
sometimes they're, especially in the intent and purpose section, it can
Right.
help you to not.
Right.
Okay.
If this was a standard zoning regulation that I was trying to enforce, I'd want it.
Oh, yeah, there's
Defined.
context sensitive, sorry. Okay,
Context sensitive is the fancy planner word of saying it matches its surroundings.
yes, that's what I figured it meant, yeah.
So you struck out 1702,
1702 got moved to a new article, further back in the document.
1703 got moved, 1704 got moved, 05 cemeteries got moved, religious establishments got moved, portable storage units got moved.
Yep,
Swimming pools got moved,
talked about that one.
10 golf courses got moved, private recreational facilities outdoor moved, sexually oriented businesses got moved, 17, 13, 14, 15, 16, and 17 all got moved. And where did they all go? Can you explain that to people that are listening?
I can go each one by each one if you'd like. Because in the, like I said, in the, sorry, I lost my spot here. PDF is not scrolling very fast. So in the digital copy of the color code, I did add notes to all of them, so I'm just gonna go through them real quick. If the note wants to work. Come on, there you go. 17, so temporary uses is now relocated to Article 24.
And what is the benefit of moving these? And I don't know, I don't even care if you go through each one of these, if the other trustees do. What's
I
the
already have
general
the notes.
philosophy of?
Well, a lot of them are still in Article 17. They just got captured in the new way we're doing all the uses.
Okay.
So they're still in 17, they just have a different section number further back in the document. Temporary uses aren't regulated as a conditional use, it's a whole different animal, hence I just moved it to a different article that's dealing with. Article 24 was vacant, reserved, there was nothing in it. So I thought that would be a great place to deal with stuff like temporary uses, portable storage units, some of that stuff that's, I guess it could have gone to general standards, but the regulations were probably a little more in depth, so I thought maybe it was appropriate to just move them into a separate article.
Okay.
Agriculture got moved to its own like I think Article 23 was also vacant, ag is just in its own standalone article, because there's just so much pertaining to ag that I felt like it was easier. A lot of times it has to do with, it's easier for me to cite when I'm writing a letter or an email. And it's easier for the attorneys to cite and find when they're dealing with things. And it's easier for me to direct people to. Like, so for agriculture, now I can just tell people, anything you want to know about ag is all in Article 20, whatever. I can't remember the number off the top of my head, 23 or 24. As opposed to saying, well, it's in Article 2, subsection 17, you know, just trying to wayfind it a little easier.
I actually like that for ag, because
Yeah.
Joe is right. Typically, it's peppered throughout a zoning resolution in different places, and you got to dig for it.
Yeah.
This pulls it all together.
So I guess I haven't mentioned that. Some of these numbers is more about making it easier for me to cite things when I write things. When I can be more easier to cite it, it makes it easier for the attorneys to do their job, and it makes it easier for the public to find it, because I can say, yeah, here's the code citation, it's here in this specific section.
All right, so that takes us to 17O. All these sections, and then my first thought, is this really necessary in our township, which is amphitheater, amusement resort, these are all new. Animal park, arena,
I guess
auction house, auditorium.
he's in the,
17,
like 17,
1703.
like we're way back past all the deletions to page like 17 dash
Starts with
16,
1703 is amphitheater.
yeah, page 17 dash 16. I guess, was that a question for the board or for me? I didn't want to answer if it wasn't for me.
I just don't, I don't, we really ever have to get an amphitheater?
I hope not.
But somebody could do a mixed-use development. I don't know. So they come in here. I think that new condo complex out there, next to the Galaxy, I think they're going to have a small amphitheater in there.
Oh, really?
I think I read that. Now, an amusement park, an animal farm.
I guess the theory, my working theory with this stuff is, just because it's in it doesn't mean we're necessarily advocating for it or want it. In
It's
some
just-
ways, it actually is dissuading it, because it looks like, to me, it says this is a community that has its stuff together, is thinking about this kind of stuff, is proactive, and is not leaving stuff up to chance. Most of those places that do the fly-by-night things, they're gonna see this and not wanna deal with it. It's too much regulations, they don't wanna read it. This community clearly has standards, I'm gonna go somewhere else that I think I can have an easier go of it. I also would argue, it sort of goes with the use table of, we had this discussion about the use table, about all those uses we're in there of. I'd rather plan ahead and have an answer for it. 15 years ago, did anyone think there was gonna be a huge prefabrication Intel plant in the middle of a cornfield in Jersey Township? You don't think it's gonna happen until it happens. I mean, there's been talk about racetracks further north and rodeos and, 20 years, did anyone, an outlet mall. 30 years ago, an outlet mall in Sunbury? Who's driving all the way to Sunbury to an outlet mall? I mean, things change, so that might not be the case now. And yeah, do I think we're gonna get an amusement resort? No, probably not. But does it hurt to have it in there? Well, it makes the document a little thicker by a page, but
It's gonna be more than a page. There's all kinds of here. Country club, crematorium, culture center.
we have crematoriums and we have country clubs, so.
Oh, we do? That's right.
We have both of those.
You live in one of them. Not the crematorium.
Yeah, I was going to say, hopefully not the crematorium.
He does not live near a crematorium.
I could go either way. It just seems like an awful lot that there's,
I
the
asked
odds
same
of that
questions.
happening is just,
No,
agree, but-
I had the.
well, we don't
I
have
just-
that available land to do that. There's not hundreds of acres for us to be
I get it,
concerned
but
about.
which one, it'll be my luck that we take the one thing out that somebody's actually proposing,
We
How do you
have
pick and
things
choose?
in our township that not in a million years I would have ever imagined.
Yeah.
So,
Fairground?
So I guess I'd rather be prepared, like Joe said, and have it in here
it doesn't
and
hurt to have it
protect
in here.
us. Yes, it makes the document a little thicker, but I think,
And I had a conversation with my husband, because, you know, as I'm reading through this, you know, sitting in bed, and I'm like, wow, this is a lot. Like, and I even wrote down, this is a lot. And he said the exact same thing. I would rather we have it in there just in case.
yeah,
And that's coming from the perspective of, you know, a community member.
yeah.
Well, that takes all my comments out. 'cause
I
it's-
did talk to Joe today about making it uniform, because there are some things in some sections that aren't in others, or it's worded differently in different sections. So just to have some consistency, rather than, why does this go by decibel? Why does this go by, you know, listening ear from the property line, or whatever?
Or even, I wonder if there's a way where there are things that are consistent that would be applicable to all of this. Could you have those kind of in their standalone
I don't know.
section? I
This
don't
is
know.
the general provisions.
Yeah.
If it was applicable to everything, we would probably stick it in general standards or in 1702 in the front. I guess because each of these tend to be looked at in a vacuum, that's why they repeat over and over.
Right.
Okay.
And most residents are never going to be anywhere near any of these sections.
Mm-mm.
Skip
No, they're
right
just
over it.
more of a future protection.
Yeah, is it a little much? Yeah, I'm not going to argue that point, but I guess in that aspect, it's the Boy Scout motto, right? Be prepared.
I'd like to bring up the boarding house section. It's on page, if you're on the red line, 17-30. You have 1722.03 and 04. 04 talks about the number of residents shall not exceed 10 individuals at any one time. I'd like clarification on, does that include the owner? Is it 10 tenants plus the owner, or owners?
It doesn't specify, so if we want to specify that, we probably
I
should.
think
have
we
that.
should. You could have a husband and wife that are co-owners, or even business owners that are co-owners, or you could have three
Where are you?
partners. 1722.03 and 04.
Those and the number of,
I would,
And
my
10.
goal is 10, including the owners,
Including
right?
those specified, I probably would just put including those specified in 172203.
Okay. And then 1730.02, the community center. We had talked last meeting about mixed use. But I think Joe was saying we only talked about it in PRD.
Yes, so this A refers to planned developments and planned zoning districts, but not exclusively to PRDs. So you could have other districts that could have that use.
So the question is, do we want planned use some places and not other places, or we don't want them anywhere?
Mixed use?
Yeah, mixed use.
I think mixed use is going to be what you're going to see the next wave of in terms of development and flexibility. Even if it's low key, I'm not talking about, we're not downtown Columbus type of mixed use, but.
Can you give us an example of what you imagine we would get?
I could see someone saying they want to convert a house and at the bottom floor have their salon and live above it. That would actually probably be a live-work dwelling type of situation, but you could have a building at the bottom. I mean, theoretically, if we allowed multifamily dwellings, someone could at the bottom floor of the multifamily dwelling want to put a commercial space that a fitness studio or ice cream shop could go in and could have the units above. This is probably more long-range future thinking. Do I think we're
Redevelopment
getting
kinda
in the
stuff.
next couple of years? No, probably not.
I had a bait shop.
Yeah.
Guy put a bait shop in downstairs, lived upstairs.
Oh, Retail.
Near Buckeye Lake.
Maximum square footage or maximum percentage of the development.
Mhm.
We have mixed-use buildings and mixed-use centers or developments, I can't remember the exact term I used, are both actual classified uses further on in this document. This specific use we're talking about in 1730-02 specifically talks about community centers, non-residential community centers. But that provision does relate to the mixed-use building provisions further on in the document. So that's why we got on the mixed-use path. So, I think on mixed use, that would be one of those non-residential uses if we're not allowed, or we won't allow in PRD. Because I think based on the prior discussion we heard,
Right.
we weren't interested in having that in PRD, so, sorry, I'm just referencing the table here real quick. Where we would, the proposed draft has them listed. So we have mixed-use centers. So once I strike it from PRD, they would be permitted in the planned commercial and planned community facilities districts, a mixed-use center. Mixed-use building, same thing. So once we strike it out of the PRD, you would only ever see it. So theoretically, you could allow for a little bit of residential development in a PCD or PCF, essentially, is what we're saying.
Where do we see those types of zoning?
Well, planned commercial is essentially Northgate, Kroger, Home Depot. So mixed use down there probably would come more in the form of like total redevelopment of the center or substantial redevelopment of the center. One of those big boxes eventually go out for whatever reason,
Yeah.
which I'm not here just saying they will. As far as I know, Kroger and Home Depot are doing very well down there. That's the long, this is sort of setting the foundation for what might not happen for a couple decades,
guess-
if at all.
So kind of like the giant eagle in Orange Township,
There you go.
that would be a good example.
What is happening? Oh, that's.
Well, it went out of business, right? And it
Oh,
sat
yeah.
vacant and
Yeah,
now
but
they're.
we have
redeveloping it.
so little commercial that I don't really want to incentivize residential in our very small commercial district.
Well, that's what would make it a mixed-use building. You couldn't just totally make it residential.
I know, but I don't know that I want any residential down there because we have enough residential already.
That's a good point.
I mean, we're almost all residential, then you got this little teeny pocket. Most townships have more commercial than we do. And so why would you allow the little bit of commercial to become residential?
I think it would be mixed use is what.
I know, but I don't want any.
I think it's trying to account
Residential.
for changes that you will eventually see in commercial, that you could see. I'm not going to say it's a foregone conclusion. Commercial real estate changes. A lot of the big box, they don't build a lot of big box stores anymore. You still get Home Depots and, Sam's Club, you still get those, but the Circuit Cities, all of those,
Yeah,
they're gone, and a lot of them have had to be repurposed to other things. Even grocery stores, the old Big Bear down at County Line in Sunbury is now Ace Hardware.
Workout facility.
The jumps, yeah, it's
Tons of
3 or 4
stuff.
different businesses. So, now I wouldn't necessarily consider that true mixed use. But I think it's just trying to set an eye on the future of, should we ever get in that position, we're gonna be prepared and not have to be reactive. So, I think you're gonna see a greater push to that.
See, I think, from my experience on the comprehensive plan, there was an area identified as a mixed-use development that was out in the rural area. gonna have a 65,000 square foot empty building that has no purpose, why not make it mixed use?
Yeah. It's very hard to
Yeah,
repurpose those
but
buildings.
that's, he was saying more, I'm talking like Northgate. I agree, like if across the street that used to be commercial, you want now to make residential, great, because there's residential all around it, but I'm not in favor of it, maybe in planning area 6, right? In that 6 down there?
Yeah, I think what Mark was saying is you get a big box building that goes out like that, they can be hard to repurpose.
Yeah,
So having that flexibility for someone to do something different might not.
Yeah.
You know, either they're gonna wipe it out, or that happened to the Giant Eagle down, I mean, this is City of Columbus, so not apples to oranges, but I think that happened to the Giant Eagle down on Neal Avenue closer to
Yeah.
downtown. Now, that's City of Columbus, but it also was a very suburban Giant Eagle. It was
Yeah.
a big box with a big parking lot in front of it.
Well, yeah, that's condos
They also
now,
did
I
that to the
think.
one down in near German Village.
Well, yeah, but it is mixed use. Yeah.
Well, I think about, not that we would want something on this scale, but what they're building next to Topgolf, that's mixed use.
yeah.
Evans Farm is mixed use.
Now, we would probably scale it down to a Genoa scale. I'm not saying we want huge block things like what you're seeing next to Topgolf. No, that would
Mhm.
not fit the character.
Mhm.
Which is why I think you write those provisions in there. I mean, if we're not ready to tackle the mixed-use issue, we don't have to have it in there. I do think it's forward-looking and probably thinking about what zoning's gonna be in the next 20 years as opposed to what zoning was in the past 20 years. Maybe 20, 30 years.
Yeah, I'm not suggesting that I'm opposed to mixed use, it's about the location and.
I agree.
where to fit.
I think what you're saying, again, if we wouldn't have so much commercial or residential to begin with, and we were more balanced with commercial and residential, but we are so residential heavy that I hate to take away from, and maybe it is too premature, that maybe we tackle this when we face the issue, I don't know.
You could provide for the mixed use in the planned commercial district only, not the planned residential district.
Well, we don't have it in PRD. The current draft has it in PRD, but pursuant to
taking it
last
out.
meeting, we're gonna take it out.
Yeah.
So it would only
I'm
be
saying is, but-
PCD and PCF. I think Trustee Vaughn's concern is that you would be losing the commercial land and giving up for some, adding residential to it. I guess my theory would be if someone's asking to do mixed use and commercial, the market has probably changed to the point where that current design and footprint is no longer viable in the market.
Mhm.
If we're to that point that someone's knocking Home Depot down and asks you to do a mixed-use building, things have substantially changed in the market.
Here's what I would say. I completely get your point, and there's nothing wrong with saying this is going to be our commercial base,
Mhm.
and that's what we want.
Mhm.
So if you're uncomfortable with the mixed-use language, take it out. I mean, there's mechanisms that, you know, if a developer comes in and says, hey, I want to pitch this mixed-use project, write a mixed-use overlay for them, right?
Yeah, there's
We-
other
we
ways
do-
to do
We
it.
do
You
that
can do
all
a
the
different
time,
zoning district.
right? And then you run it through that way, and you get it site-specific, and you get exactly what you want.
Yeah, like
So, I don't, because you're so predominantly residential, I don't have a problem with saying, we're gonna treat this is important, we want commercial only. But under existing law, there's mechanisms that someone could come in and work with Joe and the current administration to provide that flexibility, so.
okay. I like that option.
So do we want to strike
Because
the
I want to
mixed
stay
use?
open to it, but I don't know that I want to,
Codify it.
yeah, like, I would like to push that to stay commercial.
I'm okay with that.
So do we want to strike any of the references to mixed use out of the document then?
I
Yeah,
think that makes sense now, yeah.
Okay. So those are two sections in this article, so this is more of just an administrative,
Yeah.
structural question. Do you want me to just mark those sections as reserved, knowing that you might eventually want to put those back in? Or do you want me to subsequently renumber all the rest of the sections after that and bump everything
I
up?
don't see the point of renumbering.
Okay, you want me to just mark them 17 whatever is reserved?
Yeah.
And if anyone ever asks, we'll say, well, there was going to be mixed use stuff in there, we took it out, but
that's fine.
they are going to serve as placeholders, and, you know, we could always put it back in.
Yeah.
Okay. I'm fine with it. I just want to make sure I was doing it the right way. I'll strike them from the use table, and then I'll probably just do a word search and just delete it out of any other places it references it.
All right.
All right, if we're keeping all this, the other sections in 17, I'm good with 17.
The only thing Joe and I talked about was the whole inconsistency with sometimes there's low volume than the decibel. So I think you were going to work on uniformity in
Yeah,
in a
I
lot
guess
of
we
this
can look
language.
at it. I'd like to think if I didn't have them the same, that there was a reason I didn't have them
Okay.
exactly the same. So I'm happy to make them uniform, but I do think there may have been reasons why
That's
why I
fine.
did it the way I did it. I will go back and review them though, just to make sure there isn't any wild inconsistencies that obviously need to be changed.
Okay.
Decibel levels. Yeah, I mean, a lot of times it comes down to what the industry standard is for that particular use, so
Yeah.
that could be it.
So this noise control section repeats in numerous sections, but in some areas, there's only like 3 items, in some areas, there's more.
Okay.
And so what I was trying to say is, there may be a reason that it's smaller in
Okay.
some and larger in
Yep.
others, but I want to make sure to go back and that the verbiage where it needs to be consistent is consistent.
Yeah.
Bring up section 1752.01. I think we talked, this is pertaining to a bus garage.
Oh, yeah, we talked about that one today, yeah.
Not a public bus garage, correct? It would be for a private school?
Yeah, so I think I was thinking about public garages probably when I drafted that language, and the more I think about it, the more I'm not sure we need that language, because any public bus garage is going to be subject to the public, what's essentially, well, we exempt public uses under our zoning code because Pete, I think, told that story before to me of, there's no law that says public uses actually 100% are exempted, but you'd end up in court to try to prove that you could apply zoning to it, and it doesn't make sense. We've always just taken the tack, the public schools, the county, they're all exempt. So knowing that, I don't know if 1715-201 makes sense, because we know public bus garages are going to go wherever they can go. So this would just be like fleet maintenance facilities for private educational institutions. Religious establishments are probably going to be their own thing anyway as well. So do you want a fleet maintenance facility for a private educational institution in an SRR? And I think the answer to that is no. So in short, I'm proposing that we probably don't need 175201. We just delete it and then subsequently renumber everything else.
Yeah, I'd rather delete it.
Did that make sense? Yeah. I'm sort of rambling there, but. Basically, what that provision said is you could put a fleet maintenance facility associated with a private educational institution in suburban and rural residential districts.
Yeah, I think people would be upset. And then
Although, oh no, never mind, sorry, go ahead.
the next section is 1759, the gambling establishment. We talked about limiting the hours to make them similar to nightclubs. Because there aren't, I don't think you put hours of operation in there.
Oh yeah, we didn't have any hours, we could add the. I'm not even sure if you can actually open a true gambling establishment in the state of Ohio, but with the way things have been moving lately, especially pertaining to gambling, that was something I thought maybe we should get ahead of. And the legislature may pass something, we may have to blow all this up, but
Yeah, I'm not sure they call it gambling establishment.
I don't know what they're doing.
Gaming, gaming, yeah.
Games of chance is what it's called.
We can change the term.
There's a licensing process through the state of Ohio. Look at Newark. They had a lot of.
Actually, if that's the term they use, I would prefer to use the state term because
I agree.
Mm-hmm.
So games of chance establishment?
Look at Newark.
They got one.
That's what.
Yeah.
you just said.
So I think what Trustee Vaughn was just saying is she wants the hours from, we have the hours for nightclubs without adding the same provision here.
I think you also need to make sure that they're certified licensed through the state of Ohio.
Okay. Do I- Yep. It says it shall be subject to 170205, which that's the section that I put at the beginning that basically says if you require a license, that you have to have a license.
Yeah, that's fine.
Because I have that in a whole bunch of other sections too. But I'll add the hours.
And then I think 1760.09, it's under golf course noise, but I don't know that we really address the noise underneath there.
Yeah, so on those noise provisions, the hours I came up with are generally from our existing noise resolution. I just mirrored
Okay,
the hours from noise resolution. I did that homework after we talked. But I also looked at, I think, the Columbus zoning code for the decibels and some of
Okay.
the other hour stuff. Because I figured if anyone's probably researched that topic, it's them.
yeah. And then 1762.08 and 1762.10.
Oh, yeah.
We talked about merging those because they're very similar.
Yep.
They're separate.
Yeah, I'll probably just merge 10 with 8. They technically do say two different things, but it probably could be accomplished in one section as opposed to two.
Hey, can you get back to this? Noise control in a golf course.
Mhm.
Only because of a recent email we received, if you remember, Joe,
Ah, yes.
which is within 500 feet of a residential condominiums.
I'm talking about a display recently that
With
occurred.
the proposed pickleball courts.
Oh, that one.
Yes.
I thought you were talking about the other.
Well, that's what I thought too,
No. I mean, it's a valid concern if you've ever heard or played pickleball. It's not tennis.
No.
And those residents are literally, they're probably 30 feet away from those tennis courts.
So,
And our response was, well, we really don't have a.
yeah, so I'm not sure everyone knows the
No.
situation, so I'll allude to it. So several months ago, Medallion Country Club came to me and said, hey, we want to put some pickleball courts in, and we think we want to put them in over by the tennis courts. I said, okay, I'll look into it. So I pulled the plans, and the plans show that area where they want to put them is just, it's open
Outdoor
space.
courts.
And it shows, so to me, the development plan says it's open space, there's already tennis courts there. I felt like I didn't have a strong enough reason to tell them, no, you can't have pickleball courts there. You've already, and I know pickleball noise is different from tennis noise, but fundamentally, the activity is the same. So I felt like there was nothing I had on record, because again, when Medine was approved, pickleball wasn't a thing yet, that told them no. So I said, yeah, that's your open space. The plans say you're to use it for recreational purposes. Pickleball's recreation, akin to tennis. So I told them they could do it. Some of the people who live by are not terribly thrilled about that, and I completely understand, but I felt like I just didn't have anything to tell them no on that front.
so it could come under noise.
I mean, I did reply to them and suggested that they reach out to Medallion and at least have them consider some hours, limited hours.
Mm-hmm. And I felt like that was
And
the
if they're not-
appropriate place for them to air that concern was with the country club.
And if they're lighting the courts, then that's probably not the hours that they're looking to get.
Are they
hours.
lighting the course?
I think the tennis courts are already lit.
Yeah, I haven't been back there in a while, but I wouldn't be surprised. I mean, I think the ones in
Like
Westerville
all
are.
hours of the night then?
I mean, there's hours on the pool, aren't there?
Yeah,
So
definitely hours of the pool.
I don't know if there's hours on the tennis courts. I'd be surprised if there was.
All right, well, I just thought I'd bring that up. What was you were going to another one?
No, I think we covered the one I was talking about. There is mixed use again in section 1772. Quite a few references. In
Right within a
17,
mixed-use building.
Yeah, so that whole section, I might keep the term mixed-use building, but then I will just have no text in there. I'll basically
Then-
say reserved. That way we know,
Center in 1773.
and that's, I'll treat that the same way. All that text will go away and there'll just be a word that says reserve there. But I'll keep the use there so we know why there's nothing there. Be sort of it'll be the placeholder.
Okay. And then 1782.08 C. We have to put, or was it B? We have to put feet in there.
Oh, yeah, yep. And I think the next one has a similar issue.
That one I think is labeled, at least at the end. It says square feet.
I'll probably still add square feet.
Okay.
'cause we don't need some hyper technicality
Mhm.
going back at us.
Also mixed use under 1794.01.
Oh, one.
.01, first line.
Yeah, that'll come out as part of the word
Word search.
search I do for it.
All right, that's all I have in 17.
All right. 18. Sign standards. Yeah,
I don't,
I don't think there was any significant change in here, Joe, that,
No, we made a change to residential as a result of experience.
yeah.
And that's a recommended change from a legal standpoint. I think I've provided you all the privileged communication on that particular topic.
Let's go, the temporary signs has been deleted from its original location.
Yeah, it just got moved.
Still in the sign section? I didn't see
Yeah,
it.
it's 302 now.
Oh, okay, I see it.
That was my, throwing a bone, Susan used to always complain that it was terribly difficult to find and cite because it was like 1801 Q1A3 was like the citation for things. And she said, can you move that?
Yeah.
And I said, yes, I will move that because that is a big pain in the neck to try to have to cite. So we had the space for it, so we moved it.
Parking standards, any concerns with that?
no.
I did go through that because that's what I do. I didn't see anything on here that concerned me. Just to explain, if you could, I got this highlighted wide, section 1904, parking space requirements. That whole section's been deleted, not relocated.
Sorry, I'm just trying to catch up real quick. Which section?
1904, parking space
You're on
requirements.
19?
Overhauling how we're regulating the number of required spaces. So in lieu of, so number one, that list was inadequate because it didn't have every use in there. And number two, there's a big movement in the planning field to try to get away from, in fact, what a lot of communities are doing are actually establishing maximum
Yeah.
parking standards. I wasn't going to go that far because I don't think it's necessary here. By and large, we find parking tends to be a self-regulating issue because if you're a business owner, you're building a building, if you underpark yourself, the only person you're hurting is yourself. Big businesses like Kroger, they already know exactly the parking they need. They've got decades of studies on it already. Smaller businesses, sometimes they're trying to save costs, but a lot of it is just trying not to create parking fields for the sake of meeting a code standard that just are going to be underutilized, and you're just looking at impervious pavement and exacerbating stormwater issues, and that could otherwise be green space or something more productive. So it's just trying to meet sort of modern planning trends about how we handle parking. Now, I do have some exceptions in there because I do think there are certain uses that probably are going to generate higher parking demand than on average, and I've tried to call those out in those subsections 1 through 9. But, I mean, there used to be like books with just like, you get from the APA that had like studies done, and this is
Yeah.
what the APA, and like, that book in and of itself is probably a third of the width of the zoning resolution to codify the whole thing, so.
And that's, I mean, that, parking is one of those provisions where you're always doing either divergences or variances, it's just because it's so antiquated.
Yeah, I see that. What are we doing with short-term rentals?
In terms of the use,
Yeah, in general, what,
we have provisions for them in here. I mean, that was back in 17. That
I
was one of
think
the uses in
according to the
17.
chart in Article 5, they're not allowed in any district, are they? I think it's no.
use either?
Some of that was we were waiting to see what, if anything, the legislature was going to do. And I think eventually we got sick of waiting and just said, we'll just do what we do, and the legislature changes something, we'll just go back and change it.
So in section 17, it's 17.109.
So according to the chart in Article 5, are allowed in PCD. And they're allowed as a conditional use in community
R and
business.
SR.
Yeah, yes.
As well as CB,
Yep.
and then, yeah, as a planned use, permitted planned use in PCD. And then you would go into Article 17 for all those standards. And they've been a very tough thing to try to deal with, because there's
Yeah.
just, as you know, the law is always behind the times.
Yes.
And there's just, yeah, and then trying to enforce it. So I can tell you how we technically, so if anyone calls right now, number one, I know they're probably out there right now. But technically speaking, if someone calls and asks us, we say, under our code right now, we say anything rented for a period less than 30 days is a hotel, and a hotel is not a permitted use in a residential zoning district. So technically speaking, if you're asking us whether you can rent something out for a period less than 30 days, in SR, the answer is no. Now, does that stop people from doing it? No, because from practical standpoint of administration enforcement, it's very difficult. Well, not very difficult, but I mean, I essentially would have to adopt a pseudonym
And
rent
run it.
one, prove that I could rent it for a period less than 30 days, then tell Donna why I just spent the money on that. Yeah, and,
New eyeglasses and mustache.
yeah, so,
Yep.
yeah, we had one that we almost went after because it was basically being used as a party house, and it was
yes.
causing the neighbors fits. Fortunately, it sold, and the new owners either are not operating a short-term rental, or if they are operating one that is not causing problems anymore. But they're tricky to deal with right now.
Unless somebody complains, and if somebody complains,
And then it's also, there's just as many people who want them.
Right.
I mean, that's why there's the push at the State House to tell us that we can't do anything with it.
No, that is very unique, and it is personal for the rep who introduced the bill. And I am not the only one who believes that. Anybody I talk to says the same thing. Got that on the record.
Yes.
So as far as I know, though, I don't know, I haven't
Did
looked
not
at that
name
bill
drop.
lately or any other similar bills that have been floated over the years, so I don't know what its status is, if it died in committee or what, but, I say we regulate them until the state tells us we can't.
All right, we ready for 20? Landscaping?
I don't have anything in 20.
The only one I had was section 2002 is being deleted from its original location. That's being moved, right?
1603.
Yeah.
Okay.
Yeah, that was the whole section about fences and accessory walls that I didn't think made a lot of sense in that location. And then landscaping provisions are completely being overhauled.
You have quite a list of plantings that you're removing.
Oh, at the end there in 2005? Yeah. So a few years ago, the Parks Advisory Committee actually did an extensive study on that topic of what trees were appropriate where, and they actually adopted it as, I don't know if I want to say it's a park rule regulation, but a guideline, if
Yeah,
nothing else, for the parks. So I think it was Brian Wellman suggested at the time that we put it in the zoning code, because he felt like some of the stuff we had in there weren't great species, were antiquated, weren't native, variety of reasons. And I thought it was a good idea, and I felt like they had done really good work on it. So that's basically all we're doing is codifying what they wrote.
Vouch, that Parks Committee, they do their homework. Oh,
Yeah, they know their stuff.
Yep, yep.
The one we had, I don't think necessarily was bad. I think it was just outdated, because I think it was an old MORPC document, but a lot's changed on that front.
All right, very little in lighting standards, not much of anything, looks like more of just some rearranging.
Yeah, I wouldn't say anything substantive happened there.
Utilities,
I have something on 22.05. Like to remove to the greatest extent practical and possible.
Oh, yeah.
Think that they ought to do it, and if they can't, they'll ask for a divergence.
I'm sorry, which one was that?
It's 2202.05.
Oh, 2202, I was in the
Just
wrong
the-
section.
oh, I went to 2205,
That's what I did too.
Say it wrong?
2205.
Did I say it wrong?
maybe.
2202.05. Just the red part, I say, the part that was added, get rid of it.
Yeah, I remember that now. We talked about it.
If everybody else is
Oh,
okay with that.
greatest extent practical.
Yeah, I don't think we need
Just
that.
remove that. It doesn't need to be in there.
Everybody good with that?
I think it was an attempt to try to provide flexibility, but I'm not sure it needs to be in there.
The only other thing I had in this section was, I don't even know,
Small solar.
the very last page, number 8, I don't even know, like it goes back so far. Yeah, solar facilities, 2206. And that would be D. And then number 8, where it's talking about lighting. I like Joe's verbiage in the lighting section where he uses the 1 candle foot. I think it should be small, so if we could kind of adapt that language into there, I think that would be good.
Yeah, this was from the model code we got from the agency sitting to my left here. But they obviously didn't know what our lighting code said, so I think it makes sense to revise that language to fit our lighting code. It was very good language otherwise. Oh, well. Whoever did a good job.
Oh, there we go.
I appreciated not having to do all that research and try to figure it out myself, that was for sure.
And that's all I have in 22.
All right, so we're adding battery energy storage systems.
What the zoning commission thought we ought to put in. You come across that use yet?
I don't know what that is.
What would that be?
I mean, it's basically, it's a big battery, like, you build it, just sit it there, and that's what it's exactly what it says.
But is this for personal use?
For business?
These are business uses, like, they're
Business.
building these and they're storing,
Or energy?
and they're not very pretty. Here, let me see if I can.
So do we have this wrapped up to make it very difficult to?
Yeah,
here.
So I found a paper on this done by the University of Michigan. They had a whole bunch of sample zoning language, and I always like to pull from a university or something if I can, as opposed to the industry, because the industry is going to try to write regulations that are in their favor. So I had to modify a little bit because they were writing it under Michigan zoning law as opposed to Ohio zoning law. So, but most I was just removing or modifying legal references as opposed to the substantive information in it.
And Joe, since football season's coming up, it's the team up north.
Can't say that. Can't say that here.
Did grow up there, so it's, I'm used to saying that word. Although I am an Ohio State fan, for the record, as part of this public hearing. Had a very difficult 1990s. This is what those battery.
Oh, so you have like a solar field and then it's
Yep.
collecting the,
Yep. But they don't necessarily have to sit on the same site as the solar field.
yeah.
You could run the wires to it. So as you can see, they're beautiful.
Yeah.
So there's one that's, just sitting in a concrete pad somewhere.
Yeah, I like the one with the wind, solar, and the
Yep.
batteries.
Oh, yeah, you got the trifecta.
Yeah.
So, some of these may end up being public utility kind of things covered where you're not gonna be able to control them, regulate them. But I want to have stuff on the books that if we can regulate them, we're gonna have something in the books. And again, it sends the message that if you got a use like this in your code, that you're a progressive, proactive township and you're on top of this stuff.
Yeah, I've seen them, so where I have seen them is in connection with a industrial primary use, right? Not the sole purpose of the site. It's more of an accessory.
Yeah.
But they're ugly.
I think I want to say it was Chairman Leff who brought that one up, because, in his line of work, he deals with that kind of stuff.
Yeah, you must have.
Oh, sorry, I broke our Comcast connection here.
Watch a movie.
We're not watching Netflix. Sorry, don't get excited.
All right,
23,
I don't have anything in 23.
agriculture.
Oh, on agriculture, sorry. Trying to do two things at once. There is something I wanted to talk about that didn't get caught in the initial draft that I wanted to make sure we discussed. Sorry, now that I have this brought back up, I gotta get caught up here. Agriculture, that's 23, right? So, probably the biggest problem we have with administering agriculture in general, which I don't think is unique to us, is what you do with properties between 1 and 5 acres is so gray in the code. But specifically, we have in instances where we can regulate agriculture. There is, I'm sorry, I'm just trying to find it here. Oh, did I fix it here? Maybe I fixed it. There was a provision where, like, it talks about the setback of a building for buildings housing animals. In this, it's 230203A. Maybe I addressed the concern. There's a loophole in the current code.
Is this what the resident brought up at the last meeting?
A little bit.
Okay.
So, yeah, as you can imagine, there's people who are very, pro-agriculture, wanted to do it. In fact, on my way to go get dinner tonight, I saw 2 chickens across the street. But then there's people who have, when those chickens go where they're not supposed to go, or they get a rooster, or you're in the middle of a PRD neighborhood, sometimes it doesn't go as well. So there was a loophole in the current code that basically said, sorry, I had this written down and I should have made a better note on it. That said we do regulate buildings that house animals, but there was only certain situations we were doing it, and there was a little bit of a gap where you could technically be on a lot and have animals, but not be beholden to those setbacks, which didn't seem right. So I'm looking at, so I'm sorry, I'm reading what I have drafted here. Ag is such a, as Pete can tell you, that's the bane of a lot of people who do zoning's existence.
230203, buildings, housing animals.
Yeah, that's the provision. I want to make sure, I'm trying to see if the way we have it in here now, if it eliminated that loophole. Agriculture.
Setback 50 feet or more from any lot line. Buildings, housing, swine and goats.
So that's for agriculture on a lot that is 1 acre in size or less. So the question then becomes, that setback standard would not apply, I think, as currently drafted, on any lot between 1 and 4.999 acres that you could regulate agriculture building setbacks for. You want that same setback standard to apply in those situations.
You're
So,
looking at 230202C, right?
yeah, because, so,
Right above it.
yeah, so I guess that you need to sort of a primer on the ag zoning laws, I guess, to sort of understand the issue. So in the state of Ohio, the ag laws is 5 acres or more, good, have fun. Townships can't do anything, essentially, as long as it's legit ag. And there's a whole list in the revised code of what they consider agriculture. Where it gets really, really gray is if you have more than 1 acre, but less than 5 acres. Because then you start talking about percentages of dairy animals and platted subdivision. I mean, you could go on and on. There's so many ifs, buts that you can tell. It's just, yeah. It's very
Convoluted.
difficult to administer.
Yeah, so we have to allow, when a sub, if it's there, on over 1 but less than 5, we can regulate building structures
Yes.
of what's there, well, until it gets to 35%. And after it gets to 35%, then we can
Okay.
treat it as, you can't do it anymore. So that's the question is, what do you want in that limited?
So,
I
Yes,
thought
I'm remembering now what the issue is here.
her issue was, I thought she owned 2 parcels.
But they're 1 acre
Didn't
each.
want to
But they're
combine
separate
them.
lots, right?
She didn't want to combine them, but she still wanted to get some leniency on what she could do with it. That's, was the gist of it.
Yeah, I don't know how you address her situation without opening up Pandora's box.
But isn't it
Unless
if you
you-
own,
Yeah.
you have to own 2 adjacent parcels?
The combined parcels.
She could obviously do that, but you would have to carve out an exception if you're continuously, if it's under the same ownership, right? But, I don't know.
The easiest solution to that is for them to consolidate the 2 lots
Yeah,
into one singular lot. Now, they say now, to her testimony, she didn't want to do that because they want to leave the option open if they ever want to sell that lot,
I get that. But if you
but that's a choice.
get through this loophole saying that you have to own 2 consecutive lots, but if she sells it, then you're non-compliant.
Exactly, that's the problem.
Then
that's-
gets fined.
And that's why we have.
Or she'd have to revert.
And I can tell you, because I had this conversation today with someone about an accessory building. It's the same reason we don't do it for accessory buildings. Because it's all fine and compliant as long as you own both properties. But the second they decide they need to unload that property for whatever reason, now you've created a non-conforming situation.
so we prohibit, right, on,
We
is she
pay,
is she less than an acre?
yes.
Yeah. Yeah,
To me, the remedy there would be,
She
if
has
that's what
to-
you want to do, you need to consolidate the lots.
To consolidate, to fix it.
I think it's a platted subdivision, which opens its own can of worms on that end of things, but, it's the same with like the accessory building. Sometimes, like, because someone could own a property and they want to put the accessory building right in the middle and the lot line go right through the accessory building, and I tell them, no, you can't do that. Because I don't look at who owns the lot, I look at where the lot lines are, and if you no longer own that lot, now I've got a building that's straddling 2
Yeah.
properties between 2 different properties. It's just not good public
Yeah.
planning policy.
I get that.
I think it's consistent with the other southern Delaware County townships. They're faced with the same issue. And it just, I'm telling you, I'm amazed at the amount, so some people will apply for variances, like use variance to allow for chickens, and the amount of people that show up opposed is incredible. Julie just had one a couple nights ago, or last week in Liberty. So that's the problem, right? I'm not saying she's not going to be a good neighbor, but how do you craft an exception to that? And, the only thing that I can think of, and I don't necessarily think you want to go there, I know Franklin County zoning spent a number of years looking at that issue and allowing kind of like accessory structures based upon the size of your lot, you're allowed a certain number of animals. But absent
Yeah,
something like
Me
that,
and zoning always joke about that, oh, you get to go
It's the
count the chickens.
it's duck,
You
rabbits,
wanna-
and chickens
Yeah,
provision is what we
you
call
have
it.
fun counting the chickens.
Right,
So,
so.
as you know, that number tends to change for a variety of reasons. So when you
Particularly
mount
with
count one
rabbits.
day, it may not be the same as the next day or a few weeks. So, so the loophole I was actually talking about, it's related but slightly different. So for lots between 1 and 5 acres, in instances where we can regulate it, we say buildings or setbacks incidental to the use of land for agricultural purposes on lots greater than 1 acre but not greater than 5 acres must conform to all setback size and height requirements that apply to the underlying zoning district. Sounds well and good enough. But that also means your chicken coop can be 10 feet off your property line because it's accessory building. In 230203 drafted 230203A, we say buildings housing animal and/or fowl as pets for domestic use, excluding swine and goat. And then you get into there are much larger setbacks if you're under 1 acre. Do you want to apply those standards to the lots that are between 1 and 5 acres? I probably would too. I think that was an oversight to not,
So what do you do with people that currently are,
they'd be grandfathered in.
Okay.
I'm not sure how many there are of them.
Yeah.
People don't tend to report it to begin with. That may come as shock, but, so that, my recommendation is we need to, the standards that apply in 230203A need to apply to the lots between 1 and 5 acres. And I didn't come to that realization until after we initiated and much later in the process. Or you could say, no, I think that's ag and I want to be ag friendly and, you know, it's sort of, it's a policy decision really for the board. I think you heard
I'm
Pete.
okay with it, if it fixes the problem. Pete's
I'm not sure it
on
fixes
board.
the problem from the public comment.
No, but it fixes this problem. If that's Pete's recommendation, I'm okay with it.
So I'm going to reword 230202B. I like that language. I'm just going to add the language, duplicate it. I'll figure it out. I'll close the loophole. Not exactly sure how, but I will.
How do you confirm that they're pets? It is restricted to just pets, domestic use.
Well, if you're selling the chickens constantly and they're getting butchered.
You're not gonna find feed chickens on most. You need a lot of land for feed chickens.
Yeah, most of these people want the chickens because they're
They're
they
egg
want the eggs.
chickens.
Yeah,
They're egg chickens. They're not
yeah.
meat chicken and
I
egg
have had
chickens.
people ask about raising chickens for slaughter, but
Meat
not
chickens?
common.
Yeah, you need lots of land.
Yeah, to do it properly, yeah.
Yeah.
I'm not a farm expert by any stretch of the imagination, but I do know that.
All right.
I don't have anything in 24.
Temporary. Most of it's new location.
Yeah, 24 is just the relocated temporary use standards, which I think actually we got a lot of that from
1702.
Pete's office a few years ago.
25 is just restructuring.
25 is mostly just text cleanup, tidying up, nothing major.
I'm good with 25.
And the only addition here is the timeline on the application. Is everybody okay with the 1 year?
Yeah, that was a question for Pete for me.
Variance license.
On 2602.07, number 4. I think, yeah, is this reasonable, 1 year? I guess Joe said it used to be 6 months, right?
Well, we used to not have a tabling.
Oh, okay.
I mean, so
You could table indefinitely.
more often than not, there's nothing in codes that address this, but this is becoming more and more frequent. So I would say anywhere between 6 months or a year. Unless the board or the zoning commission says
What's the difference
otherwise.
between tabled and continued?
A tabling means you're no longer really being heard. You've been continued indefinitely to a date, time,
Oh,
place
so
uncertain.
continued, you set a date.
Continued is, so the way we do it, now, people use these terms
Yeah.
differently in different areas, but the way we've used it in Genoa since I've been here is, if you're being continued, that means your hearing has been continued to a date, time, and place certain.
Correct.
If you're being tabled, it just means you technically have not withdrawn, but we don't know the next date in which we're gonna deal with
Okay.
this business.
Okay.
And then you have to pay to have that application untabled because we have to run the ad again.
Right. You've had some good training, Joe.
Yeah, it's like I listened during those OTA sessions.
So what's the harm in 1 year? What do we care?
I think 1 year is fine. I just wanted to,
6 months seems short to me. It can take 6 months to hear back from a state agency.
Yeah,
If you're tabling to hear back from,
yeah.
Someone-
Environmental issues or
yeah,
whatever.
yeah. I know a year sounds like a long time to people, but in the regulatory world, it's nothing.
We're already in August. A year is not a long time.
Yeah,
It goes
exactly.
so fast. So fast.
There's the same provision under 27, tabling for a year.
I have a question on 27.
Okay.
There was a, I don't even know what section it's in. But there, something, well, actually, maybe it's later in, I should just wait. I don't remember where it is in this section 27, but it was brought up that we used to rezone, even though we have a two-step process, we didn't rezone the land until the final development plan. Now we're doing it with the first step process. So when technically is the land supposed to be rezoned? Let's say you go from rural residential to PRD.
When they file the zoning map amendment. And I don't think we can actually stipulate when they file the zoning map amendment application. So we've always tied it to the preliminary
Right.
development plan application because that's generally what they're gonna wanna do.
Yeah, that's the way it should be done.
Yeah.
I don't-
agree.
Doing it, it should be
Right
the
now,
way?
correct.
Yeah, okay,
Yeah, you're correct. You're doing it the right way.
okay. All right, I'm just wanted to clarify that for the record.
That process is state mandated in terms of how that all works. That's the whole point of then applying for the preliminaries. They want to, they call it secure the zoning. They want the zoning district approval in place. So they're always going to apply with preliminary, and for good reason. To do it the other way, I think, would be backwards and probably cause problems. Now, does that mean you could have a property rezone and then they don't file the final and you've got a property sitting there vacant in a different zoning district? Yes. But they could always sell it to someone else who wants to develop under the rules for that zoning district, and as long as they comply with the rules, then theoretically it should be an okay development. And they do that with sort of the risk knowing that the rules could change.
And then 2704.22, that whole section, there's been a lot of questioning on, are we giving developers too much time? I think somebody calculated, like, if you took the maximum amount of time through each of one of these steps, it could take you 12 years to develop a development.
Now, this is just for approval of the plan, the plan approval. So you have to apply for the final plan within 3 years, unless the township at its discretion grants.
My question is, do we mirror regional planning? Because doesn't regional planning require you to come back? I thought it was after 2.
We're actually looking at changing some of that language right now. Don't ask me to quote it off the top of my head, but we're running into the problem where we're getting so many extension requests because development's just not quick.
Slow.
And there's so many things outside of a developer's control that can just slow the whole thing down. Now, are some of them self-induced? Yeah, probably. But so at regional planning, we're looking at making the window longer before you have to come back and get the request, granting staff some of the administrative capability to approve those requests, because a lot of them are just like
Yeah.
rubber stamping kind of things, but also putting in better standards of review for the requests, because sometimes they were having to come in front of us at regional planning as variances, and the variance standards were really not written to deal with, for that type, they're dimensional variance standards. They were only really written to deal with time issues, so we're drafting standards that we can review extension variances against that are more pertinent to time. So I guess on all this extension stuff, I would point out any of those extensions is, if it comes before the trustees, it's all may and discretion.
Yeah.
And all it does is, it just gives you the guidelines of this is, if you remember the last one we did, the 2 of the trustees were here a year or so ago, which ended up not going anywhere, and that development didn't happen anyway. They requested the extension, but the board you didn't have anything to review it against or guidelines to go against. So you just sort of had to sit there and see how you felt about it. This at least gives you something to think about, like, here's the things you ought to be thinking about. I mean, I understand if you were to grant all of these out, it could be a long period of time. Now, if the board, I guess that's, to me, the discretion of the trustees. If the board feels like it comes in front of them and they're comfortable with that amount of time, and they think there's a reason to grant that kind of time, then they'll grant it. If they think it's exorbitant, they'll deny it. It's sort of the board prerogative there. Putting the power in the board's hands to make those judgment calls.
You and I talked about a combined submittal.
Yes.
Your take on that? I'll tell you mine.
Explain a combined submittal.
So if you recall at the last meeting, in a couple of the different districts, we gave applicants the option, not necessarily the requirement, it's an option, to, if they meet certain criteria, to take the two-step process and consolidate it down into one. I'm in support of it if we can figure out what the parameters of that should be. Because I think there's certain developments that we probably spent 2 meetings on, that stretched over 8 months, a year, that we should have been able to get done in 3 or 4 months.
JC man.
I would say that was one of them. I would say the multi-sound studio was another one.
Yeah. So what it
That
does is
took a
allow
year
you
and it didn't need
combine
to.
your preliminary and your final as one submittal. You're
Yep.
taking a chance because you're gonna provide detailed information like a final.
Yeah, you're gonna do all the engineering.
Yeah, you're skipping a step. And those would have been perfect candidates for a combined.
Yes.
submittal.
Singular building, not that large, relatively speaking. We could have easily done that in one step.
Okay.
And I'm seeing that more and more
Yeah. I am
with
too.
code updates. Yep.
I think especially with larger townships, as you grow, like when you're a rural township and you get a 5,000 square foot building, you don't have a lot of other commercial development, that's a big deal. For Genoa townships, as we've grown 3,000, 4,000, 5,000, that's, just not as impactful on us. We know how to deal with them. They're probably in locations that they make sense if we've done our zoning correctly. So I think it's one of those things we could be more user-friendly. And then the public gets worn out with it too, because they come to those meetings, they think it's done, and then they see a sign, 6 months later, they seen another sign go up, and I thought we were done with this. Why are we still talking
So
about
why
this?
aren't we adding it?
Oh, it's in those districts.
Oh, okay, good.
Well, we didn't need to do anything here, because those districts are basically saying, just take those 2 sections and combine them together.
And then what about the discussion you and I had about turnaround, the township's turnaround period to respond to an application in adequate time?
Oh, you mean doing the review?
Yeah.
That's sort of always been an internal policy, because we have never codified that process. That might be something we want to look at independent of this. I don't necessarily think it's a bad idea to look at it. I'm not sure we want to tackle it with this. So what Mr. Antonetz and I had discussed was, so if you don't know, usually what happens is most development applications are due approximately about a month before your meeting happens, give or take. That is designed to provide you adequate time to receive and review the materials, and me adequate time to review the materials, and accounts for, people are on vacations, and we have to run advertisements anyways, so provide some leeway for that. So what I do is, once I do my review and finalize my review, I send that report out. My target is about a week in advance. Now, there's nothing that says that I have to do that. There's nothing that says I couldn't slap that review in front of them right before the meeting starts. I would never do that to somebody, but theoretically I could, I guess. To me, the idea there is it gives them a week's time to sort of digest it and understand where staff stands and what kind of questions to possibly expect. But I always couch that with, I'm only speaking for staff. The trustees or the commission may have additional questions that are not in this document. But what can also happen is that comment report can also have a lot of hyper-technical corrections, or things that possibly the applicant wants to try to address in advance of the meeting. Sometimes a week is not a lot of time to deal with that, or sometimes they'll try to address it, but it's always been each commission and board over the years has had different philosophies as to whether or not they are willing to entertain what I would call 11th hour revisions in the days, hours leading up to the meeting. Some boards are more willing to entertain them, and other boards have said, no, that was your application date. You know, it's unreasonable for you to expect that I'm available. If you send this at 12 o'clock the day of the meeting, that's sort of not very respectful of the board's time, that I'm not just sitting around waiting for your revisions to drop, and I've already spent significant time reviewing this, and I'm not going to drop everything I'm doing to try to review this in the last couple hours before the meeting. And it can be hard for staff too, because we don't always have time. You know, we get it, and then we have to distribute it. So what Mark and I were, Chairman Antonetz and I were trying to discuss was there a better way to get them that information and give them an opportunity to revise the plans before they even come to you for a meeting? So we can hash out some of the hyper technicalities, and your meeting can be spent more on
Yeah, big picture
the big
stuff.
picture, higher level concerns. I think, I mean, we could do that. It's just, what would that look like? Number one, it's going to be hard with the zoning map amendments because we have to follow the state mandated process. So for preliminary plans, zoning map amendments, I think that's hard. I'm not sure we can do it. At least not leading up to the first hearing. Once you open that first hearing, you've opened the hearing. I think you've met your statutory requirement, and then you can take how many meetings you want.
I do think, though, with the law change, you used to allow a month because you needed to advertise, but now we just have to put it on the website. So,
Yeah, but you're still at 10 plus days.
All right, so this, if I could interject.
Mm-hmm.
So, and this is not a rezone.
Correct, yep.
This is Gehanna, and Gehanna goes through a design review, which essentially we do a design review as part of the rezone. But they won't even schedule the hearing until the staff and you agree on all the items. So that way, when you go to the hearing, staff is already on board, or if there's 2 or 3 items you can't agree to, then that's the focus of the meeting. It's not, did he cross this T on page 5?
right.
So, in one of our Sandsdecker's applications, I gotta think about this because I didn't directly do it, but the application, I think the staff review came to Sandsdecker. I think it was McKinsey, it was on J.C. Manning. Literally responded to those comments either that day or the next day, and it didn't get put onto the next hearing. So J.C. Manning comes in, and all those comments that we addressed were still on the agenda, talking with the zoning commission when they could have been
Addressed.
And that's the kind of scheduling I'm talking about, is at that ample amount of time where the applicant can address all of those, even if you schedule a special meeting or you notify the commission that, you know, we're not prepared to discuss it because we just got recent information. That's the timeline I'm talking about.
Yep. So sometimes,
You have time to review, your review gets to the applicant, they have time to respond for you, and you can say, look, I need this in 48 hours. If you get this to me in 48 hours, I will review it, and it will be addressed at the meeting. And that's where J.C. Manning got so frustrated, because she was getting information that we've addressed all these things. We come into the meeting, we've addressed all these things, and they feel like that they should be off the table, but yet it gets discussed at the zoning meeting. I don't want to get into the weeds on with you now, but that is something that I think we need to address at some point.
Yeah, so I think that's, I wouldn't put it in the code.
Yeah.
I think that's just an SOP and an SOG. Yeah.
so what I will tell those applicants sometimes is, they always have the opportunity to continue to take the time to do I mean, it pushes it back a month, but they could always continue to clean it up before they want to go. So sometimes it's a strategic decision for them, because I always say, well, you could continue and address all my comments, but I can't guarantee you that the commission's not going to have additional comments. that then you're gonna have to deal with and spend another month trying to respond to and address. So I tell them, you sort of always have a choice of, do you want to try to clean up everything for me and then roll the dice and see if the commission's gonna, or the trustees are gonna make you do anything else? Or do you come to the meeting thinking that you're probably gonna get continued, but you hear that feedback first before you make the revisions? I think it just, yeah, we could talk about it more, because I wanna make it work, and I don't want what happened there to happen again, because I
I'm-
agree that was not ideal, but I think getting a board or a commission revisions, I think there needs to be a drop dead point of expectation, because it could be, staff, just for whatever reason, if you do the revisions on Wednesday, but I'm out Thursday and Friday, I'm not gonna have, I don't have time to look at it. Like, we put the calendar in place for a reason, we all schedule around that, and I schedule around that, knowing I need to get this review done about a week ahead of time, so I can send it out, so everyone knows what's going on. And, there are people who do, stuff like the next day, but there are also people, it's 2:30 the day of the meeting, and they're trying to send
No,
me
yeah,
stuff.
I've been on the other side of that, and I wasn't
I'm not
here.
saying J.C. Manny did that, but we've had that happen before, and it's just like, most people are, I've gotten to meetings like that, and the board members like, I haven't even seen it, I have not looked at my emails, I went straight from the office and I came to this meeting, so they've not even had a chance to look at it, so.
I do think sometimes, though, that the zoning commission could meet twice a month to help with the timeline. I mean, why are they stuck to once a month? Sorry, you got to wait 4 weeks. So why can't they schedule a quick meeting, 2 weeks out to speed up the process?
There's nothing stopping them, I mean, it's their prerogative, though, so
That's
that's
what I
one of
mean.
those.
I think the mindset needs to change.
So that's good information. I wish Chairman Leff was here. To
Yeah.
see. He might, I'm sure he'll listen to the meeting. So I'll provide them that feedback. That's one of those issues. I can't force their hand
Yep.
on it if they just decide they don't want to do that.
Yeah, it's clearly a procedure. Because if you're getting the applicant's response, I mean, within, anticipated time of 24 hours, and you can express to them that still isn't going to give me ample time to present this to your comments to the zoning commission. Do you want to continue the meeting? And then they can come into the meeting knowing that they're going to continue it.
Yeah, and I try to communicate that to them.
Topic, you were talking about your staff report. I went to an OTA webinar, and they recommended that that be made available to the public, either a week or at least a couple days prior to the meeting, that it's posted online or whatever, just so there's that transparency and the public can see it.
I have hesitations, I suppose, about doing that. I'll let
Did
Pete-
we teach that?
I don't know I can't remember. I mean, I could probably go back and figure out which one it was, but it was this winter.
It's a public record.
Correct.
I mean,
It just takes a minute. When people want it, they can't get it.
yeah, I mean, I'm not opposed to some sort of posting. I mean, if you're putting the application online and hearing notice and all that stuff, I guess to me, it's when you put that step.
Yeah.
When you put that staff report on.
If you put it online, you wouldn't have to read it word for word. It would save a lot of time during zoning hearings.
I guess what's your reservation?
I guess I'll have to think about it. I'm not sure. I might
Just
wanna
trying to
have that
speed up
discussion with-
our process. If
I
you-
might
if
wanna-
everybody
Attorney-client
can read
privilege.
it, why do you have to read
Well,
it?
I think I want to talk to Pete about what my concerns are to see if
Yeah.
it's a legitimate concern
I'll
and
go,
whether or not it's.
I can probably pull it up on my calendar to see which one it was, OTA.
Yeah, I mean, I'm
Door on
not
it. I
dismissing,
just
yeah,
wanna-
I'm not
I wanna
dismissing
give it some
Joe's
thought
comment. I mean,
first.
we do have clients where they'll put staff reports online a couple days ahead of time.
It was a
Obviously-
zone, I know who it was. It was a zoning director in like Jerome Township in Dublin. And what is that? Jerome Township in,
That's a client.
yeah, it was a zoning inspector.
Eric.
Yeah, does he do to OTA? webinars?
Yeah,
Yeah, it was him.
yeah.
It was him.
And Eric also, his background also is big city, too.
Okay.
So City of Columbus, City of Reynoldsburg. Yeah, it's really a matter, I think, of preference, right? I'd be more than happy to talk about your concerns offline.
Yeah, I might just want to bounce them off Pete before I
but
maybe
yeah.
take an official position on it.
All right, let's get back. This appears to be, we've done our review.
Close, we're close.
There aren't any more comments on
There
this
are.
That
Listen,
closed up
are
too
you
fast.
kidding me? I just have a few for somebody that we all know. Joe, can you address 2706.19? There was, again, it's the timeline. You and I discussed this, that how it is not advantageous to developers to delay.
Yeah, I
Okay.
mean, no developer wants to delay if they can help it.
2706.19, again, it's like the timing again, too much time.
Also point out
Did I say it
That-
again wrong?
that
Sorry.
3 years is just the timeline that you have to pull a zoning permit for the project.
Okay,
How long it takes you to complete the project, we really don't or really can't get involved in that. If a housing development takes 20 years to complete, it takes 20 years to complete. All this is talking about is you've got 3 years to pull a zoning permit from that project. Once you pull the zoning permit, a totally different clock starts ticking, because then there's the clocks that we have for the zoning permits that we talked about in Article 1 at the last meeting. This is just, if they don't pull that permit and they want an extension, again, it's the same as the preliminary development plan. It's all discretionary, all up to the board. If you think, no, I'm sorry, I don't think you warrant an extension there, I have concerns about the direction this is going, I'm not buying what you're selling, kind of thing, you don't have to approve it.
okay,
And I've seen codes go up to 18 months for an extension. So 12 is right in the wheelhouse.
Okay.
It's typical.
thank you. And my last comment is 2707.05.
Mm-hmm.
The question is, can we remove it?
Yeah, this
There's
is,
a
I'm
push
familiar
to
with this comment,
Get
because I think the
rid of
commission
the
got
whole
it.
section.
I'm sorry, 270705?
2707.05, yep, the whole
The
divergence.
concern is, I know this concern because it came up at the commission level. I'm pretty sure it's the one that I'm thinking of. The concern is over the phrase "or not having an adverse impact on."
Yep, well, that and the whole section,
Oh,
A through G, yep.
removing
They
divergences?
want it
No.
all
I would not remove
removed.
the ability to review grant divergences.
Can you? Yeah, you can.
Mhm,
Do you want to? My recommendation would be absolutely not.
no, okay. And can you tell us why?
Yeah, you need to be flexible. That's the whole purpose of plan development, right? And I think you need to be flexible. There is no one size fits all, and you need to have that discretion. And what's listed here, A through G, is kind of your guardrails, right? And what you're going to look at in making that determination. But ultimately, the decision is going to rest with the elected officials. And yeah, I would not, if you're going to have planned districts, you need divergences.
Okay. And then can you discuss the or? 'Cause
Yeah.
there is a push to get rid of the or.
Yeah, there's a phrase in there in the opening paragraph that says, "or not having an adverse impact on." That got added several years ago. I can't remember which amendment it was. I was always, my concern there when we added that verbiage was there are certain divergences that don't necessarily promote public health, safety, morals, and general welfare, but are also completely insignificant, non-injurious, hyper-technical, doesn't matter, no-brainer to grant. If you take out the verbiage or no adverse impact on, technically speaking, as enforced, some of those divergences that should be no-brainers, if someone wanted to be very strict in applying, want to be a I guess, strict constructionist in terms of the language, you would have to say, no, we can't grant that divergence, because it does not promote any of these things. So to me, it's a reasonableness standard and a flexibility that you're adding in there that just says, we fully admit that some divergence requests just have no significant impact on anything, and though we should not be denying those just because they don't conserve or protect natural resources, or just because they don't technically check any of those boxes. I guess that's.
I think it's a philosophical difference, though, that this person does not want divergences granted ever.
Correct.
Yeah, so on that point, I defer back to what Attorney Griggs just said regarding divergences. I know there's a philosophical opinion out that divergences are bad and should never be granted, you know.
We can always say no.
Yep,
Correct.
that's exactly right.
If you don't like the divergence, you say no.
Thank you. That's all I have.
Trustee McMurray?
Nothing additional?
Okay. I'm going to make a motion to continue.
Oh, yeah.
Oh,
I
yeah,
have
we
the
need
dates here
to,
somewhere. We're starting to run out of dates in August, unfortunately. In August, we're down to the 19th or the 25th. So Mr. Griggs says 25th's not great for him.
yeah, 25th won't work.
What about the 19th?
19th is, looks good to me.
So that's a
Don't
week
know
from
if
tomorrow.
That gives me ample time to meet with,
Okay.
That's true.
So you want to push it to September?
yes.
Okay.
So then in
Next
September,
meeting will be September 9th.
Yep.
if you want to have it before then, we are looking at the 2nd, the 3rd, or the 4th. 2nd is obviously the day after Labor Day. I don't know how that impacts people's schedules.
I'll be in Georgia.
You want to do Wednesday, the 3rd? Is the Parks Committee in here? How are we doing that? Are they not meeting? Maybe they only meet every other month now. I think they said they weren't meeting as often.
Yeah, I thought they had cut down on their meetings too.
Okay.
I can't do the 3rd, but I can do the 4th.
I can't do the 4th.
Okay.
Sorry.
How about
The 15th?
Monday, the 8th?
That's
This
not an
isn't,
option.
no, the next option after that is the 15th. Yeah, I
The
can do
8th
the
would,
15th.
I don't know what the zoning commission's going to do. The 8th is zoning commission meeting night. Now, they don't have any applications, but they haven't yet canceled that meeting, so I can't say
I
that
don't
night's
want-
available yet.
I don't have to dance around that. We'll just do the 15th.
Monday, the
That works.
15th?
Yeah,
That work?
yeah.
Okay, so I move to continue the public hearing for the subject zoning text amendment dated June 9th, 2025, also known as ZC case number 2024-05, until Monday, oh, I lost my date. September 15th at 6:30 at the Township Hall. Do I have a second?
Second.
Discussion? None? Roll?
Roll call, trustee Vaughn,
Yes.
trustee McMurray,
Yes.
trustee Antonitz.
Yes. Having nothing else on the agenda, do I have to come out of this meeting? Or I just adjourn? I move to adjourn this meeting at 9:09 PM. Do I have a second?
Second?
Favor?
Aye.
Aye.